My lord, the item number 13, my lord. Ananta Prasad, my lord. The reliefs which have been paid for in the petition had all been granted, my lord.
Mr. M. Sharma, appearing on behalf of the petitioner, submits that the dues that the reliefs which have been paid for by the petitioner have been duly granted.
My lord.
And as such, the petitioner would not further like to continue the present petition. Mr.
And Krishna, my lord.
So and so appears on behalf of the court. Accordingly, the petition stands closed as in proxies. If the immortal dependent stands taken.
My lord.
May I please your lordship, I beg to mention for listing of a WPC lordship, which was filed on 16/10 lordship for tomorrow lordship.
Why?
Lordship, it is challenging the notice inviting tender lordship. Lordship. Lordship, another same pair for another matter which was filed on 29/10 lordship. Similar pair lordship.
Actually, I'm praying for listing of an IA lordship. In the IA, we are challenging the award of a tender contract, your lordship.
Challenging the
awarding of a tender or rejection, your lordship, in IA for tomorrow, your lordship.
awarding of a tender by an I.
Lordship, initially, when we had come up, lordship, we find that the court had said that everything will be subject to the outcome that the respondent authorities will consider a bid accordingly. But lordship, what they have done, they have gone beyond the order of this court, lordship, and they have not considered a bid, your lordship. That is why I filed an IA, lordship.
That may be a case of contempt or a fresh course of action.
Lordship, otherwise, IA for tomorrow, your lordship.
I know.
There's some urgency, lordship.
Otherwise, I don't entertain it all.
There's some urgency, lordship, for tomorrow, lordship. There's some urgency,
What
lordship.
is the urgency? If you are filing the wrong petition, why should
Not wrong petition, your lordship.
the wrong-
If lordship goes through the matter, lordship will understand the context, lordship, for tomorrow, lordship.
Tomorrow is Friday.
Lordship, tomorrow, lordship. Some urgency, lordship.
Hello, last item.
Lordship.
May I please your lordship. Lordship, may I pray for listing of 2 writ petitions for withdrawal, your lordship.
When?
Lordship, next week on Monday.
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 What do you have?
Lordship. Lordship,
Better way.
Lordship, we had sought instructions from the petitioner, your lordship. Lordship, the petitioner was of the opinion that 2.5 lakhs or such odd amount was already paid.
So remaining you pay.
Lordship, if I would make a submission, your lordship, if that amount was given during that time, it was not disclosed as per it is only 10% or 50% or what we were in the
The
bonafide.
council, why you are not understanding?
Lordship.
At that point of time within the city, it was not permissible. Now in view of this clause, it is now permissible.
Lordship.
That is why I say problem arise. That is why it was taken very easily by also the revenue. The revenue also did not think about it.
Lordship.
That the particular amendment is such nature that earlier it was not permissible. If it comes within the city limits,
Lordship.
then it was not permissible. The Temporary Settled Area Tenancy Act did not apply.
Not apply.
It was because of that, the amendment has been made in respect to section 2C, section 2, whatever may be, wherein it has been said that now city lands is still outside, but if so and so remains out there, then it is permissible. So therefore, now your right of a khutiya in respect to that land was on the face of it actually illegal. If it is brought within the purview of the Temporarily Settled Area Tenancy Act, khatiyan is on the basis of the Temporarily Settled Area Tenancy Act. Otherwise, you don't have the privilege of getting a khatiyan.
Okay.
So therefore, you need to either do the other thing, whereby check out the genealogy of this particular person, saying that he is the owner. And as such, the sale was made by the owner. That you, if you wanted that, that was one aspect. And if that is not there, the second aspect comes in. Khatiyan. And the first aspect also, there is a problem because he sold it in that manner. Isn't that, Mr. Gorguzari?
Yes.
So better off you pay that minus the 2 lakhs. I keep the matter pending.
Lordship.
and give you the liberty to pay that remaining. And so that they correct, and then I close this contempt.
Lordship. Apu.
Because admittedly, my lord, in the same deed itself, the schedule reflects that it is 30 and my lord.
Understood, whatever may be.
Yes.
So therefore, let him pay that remaining 21 lakhs and all. Minus that amount which you have already received.
Already be provided.
Received, which you have duly acknowledged. So let him pay. And then you take up the action and we take up the matter after 1 month.
Lordship, sometime may be given 2 months, as I have been instructed by my
Don't delay.
Lordship, 2 months.
I
It
am
is,
a person who is more considerate, giving you this. You make the payment, it is much better. You understand that?
Lordship.
Then you get your right concretized by this court itself.
Lordship. Lordship, I have just been informed 1 month would be fine. Yes.
That is what.
Lordship. Much grateful. Lord.
In terms with the instructions affidavit so filed by the respondent, wherein it has been mentioned that the petitioner, the more particularly you have filed the tenancy cases,
Lordship. On our behalf.
whereby it has been mentioned that the petitioner have been asked to deposit an amount of rupees 23,33,5520. Is that minus 22 lakh 50 the earlier amount
No, my lord.
and deposited so and so for the grant of the patta? Mr. T. Kashyap, appearing on behalf of the petitioner, submits upon instructions that the petitioner have already deposited an amount of rupees
Like,
2,28,480. And this very aspect is also admitted from the statements made by the respondents as well as the materials placed before this court. The learned counsel appearing on behalf of the petitioner submits that the petitioner may be given the liberty to deposit the remaining amount to by way of challan. In terms with favoring whom?
My lord, the district commissioner.
District Commissioner Kamrup Metro.
My lord.
And thereupon, the respondents be directed to take appropriate steps for grant of patta. Mr. R. Bubazuri appearing on behalf of the respondents, as well as who is also the standing counsel of the Revenue Department, as well as Ms. Yudas, the learned counsel, who also represents the district administration, submits that upon deposit of the said amount, after deduct the amount upon deposit of the amount of rupees 23,33,250 minus what would be the amount?
Lordship, 2,28,480.
2,28,48.
No. Upon deposit of the amount of rupees 23,33,250 minus rupees 228,480, that is rupees so and so.
21 lakhs. 40.
The revenue authorities as well as the district administration shall do the needful. Taking into account the above, list this matter again on 1610 on 25/11/2025 for an update showing it as part of.
Much.
So,
You immediately do it,
Lordship.
so that we can get it done.
Got
And you also think.
yes, absolutely, my lord, absolutely.
A that so upon deposit, the chala, for an update will be. The petitioner is given the liberty to submit the challan of payment of the said amount, minus amount, along with a certified copy of this order to the Deputy Commissioner, District Commissioner, Kamluk Metro for doing the need. So, like, list the matter on so and so for an update. None appears for the Guwahati High Court. Oh, yeah, he is appearing. What do you want?
Lordship, matter pertains to regulation of service, my lord.
Realization of
Yes,
the what
yes.
provision?
Page 22, my lord. Since 2013, my lord, I am still,
People cannot be regularized,
my lord, for decades, my lord, still I am working and getting salaries, lordship.
but how can a sweeper be regularized? They cannot regularize anybody out there, taking into account that there is already an office notification of the government of Assam saying as regards the sweeper aspect has to be outsourced. Can't be regularized. Now what has happened? You have gone before the person who has appointed.
And we have made already representation also, page
Say that,
86, my
Mr.
lord.
Das.
For,
You know, goes with this petition before the person who has appointed him.
Those days we don't think, sir.
Back. The government's notification is well. Where is the finance? Mr. B. Gogoi and all? None. Okay, let us issue. I'm more kind when the matter comes for Guwahati High Court. I'm more kind to the petitioner. I'll issue a note so that we can dismiss it on some other day. Let them come up with their reply. But in fact, it cannot be permissible.
Sweeper, the one is absolutely clear. It has to be outsourced. It's just-
Like we are taking up the matter pertaining to toilets also.
There also.
There
contingent-
also, it's all outsourcing.
Outsource, either outsource, wherein outsourcing agencies are available, or contingent fixed pay basis.
Now you are still working.
yes, my lord, still working and getting salaries, my lord.
Show me your last. It is until further orders.
Yes, my lord,
Fine.
until
Yes.
further.
From where is the district judge making the payment? Because the problem arises, that day also I was saying somebody, the problem arises because of that. Mr. Borpujari, you have a particular notification of the finance, wherein sweeper has to be outsourced,
Yes, 2012 poem is there.
2012.
Clause 7, but clause 4, yes. Clause 7.
That is what, they have a problem, they cannot do it. And secondly, if a person is on a temporary appointment, Mr. Das, how is it possible? This is until further orders. This is the biggest problem which we are facing. It has to be per every day, means every year there has to be a proposal to the government.
For release of the salaries and all.
Because this does not come within the ambit of the consolidated fund. So it has to be every year, there has to be a proposal, there has to be an additional finance budget for this, isn't it?
Yes.
And if this proposal is not there, from where is this district judge Dorong making this payment? And now you are getting how much? 9.
9,000, lordship.
And you are getting payment.
Yes, my lord.
Lucky you are.
Still I'm not working.
Understood, but how can you get it? But this goes against the government's policy, na? Wherein it categorically says that there cannot be any appointment, and that too, it happened in 2012.
My lord, I'm working without break, my lord. That is matter, my lord. Without
What?
breaking, I'm working, my lord.
Without break.
Yes, my lord.
That is
Since
good.
2013, my lord.
Because if you work with a break means until further orders, this order becomes useless. You should also make the government a party, the state judicial department is there, na?
Yes, judicial.
Okay, for judicial department, who is appearing? You. You take it up with the finance and also take it up because this is an issue which has to be drawn by the finance because this regularization will have an impact upon the finance. Isn't it, Mr. Borpujari? Because any regularization order given in respect to a sweeper out here will have a cascading effect on all other matters where we don't pass any orders to them.
Firstly, my lord, that notification is there. Secondly, my lord, after 10 days, regulation is not permissible. If my lord, they are even wanting, so because he will fall within the category of my lord, officer or gateway. Because his appointment right now, what I understand is that it is in the nature of casual appointment. That is not permanent. And my lord, moreover, they are from looking at AFRBN Act is also there. Who has granted this issue.
But the fact remains that Upendas, how do you bring in Upendas out here? If I understand properly, Upendas was a case wherein a lot of people asked for regularization. The court said that we cannot pass an order for regularization. That is one. But the court further said, but there was a consensus on which you say that those people who are working for the last 10 years
10 years.
will do so.
Not in sanction post.
No. 10 years we will do so.
That was one time measure.
And that was a one-time event. But that does not stop the concept of regularization, taking into account that in view of the recent judgment passed in Dharam Singh,
Yes, Dharam Singh.
the Supreme Court had stated that maybe the High Court may not have the direction authority in view of Uma Devi to pass directions for regularization. But the High Court under 226 can very well look into it as regards the or there can be a scope of judicial review as to why no such decision has been taken as regards not regularizing them, taking into account for that these people have been working for long. But another aspect of the matter, there is still a further differentiation to that, taking into account that in Dharam Singh, those people were working in the year 1990, much prior to Uma Devi. And Uma Devi's 53 may come. That is another aspect. These are various fine tunings which has to be done in view of these three judgments of the Supreme Court coming after Uma Devi, which just slightly deviates from Uma Devi. Kirpal, na? What are the
Dharam
three
Singh, Dharam
judgments?
Singh.
Tripal, Jaggu and Dharam.
Ah, Jaggu is there.
Jaggu.
Then again, while deciding Purnima Maranopsis has dealt with that, my lord, Jammu Kashmir versus Bar Association Bandipura, where it has been stated, my lord, that, my lord,
Therefore, you see, the thing is like this.
State, my lord.
First, if you see the judgment in Jammu and Kashmir versus District Bar Association Bandipora, paragraph number 26, the Supreme Court makes a very fine distinction what can be regularized. Regularization can be done in respect of irregularity.
Yes.
Irregularity means, and if you see the 1997 judgment, I forgot another name. What is irregularity means? A person having been already appointed to a sanctioned post. And against that particular, there are some irregularity in the procedure. And thereby they are therefore regularized. You can, it further says out there that it is not a concept of recruitment.
So therefore, the whole law of difference should be made by whether, by the nature of the post. If it's sanction post, that is whether government has earmarked, there is a requirement, there is a necessity of service from a person to be appointed there. So it is serve the government. Now, if it is not appointed in any sanction post, that means there is no requirement of service by the government from any person.
That is why the problem arises with the three judgments. That if you require his employment for the last 10 or 12 years,
Yes.
why you are not sanctioning the post?
Yes.
And this non-sanctioning is subject to judicial review. This is Dharam Singh,
Right.
isn't it?
The issue of sanction
Here-
post is also involving Dharam Singh.
Lordship,
The issue of sanction post is also.
So that is why it says that if you keep him for a long time, and thereby you just give him like this violates the principles of Article 14.
Honorable Apex Court conceived in Dharam saying that sanction posts are there. Say for example, A is a post. You are not filling up the sanction post by regular employment. You are utilizing this person's service on those posts because they were working, they were discharging those duties which were of the sanction post. So how can you do that?
No, there also says in Dharam Singh that non-sanctioning of the post
Yes,
also would be subject to judicial review.
Yes.
So if you require, so therefore now unless your decision is there that you are not going to do it, but the fact remains at the end of the day that without there being a sweeper, the court, none of the court's establishment can run. So have you developed your argument on the basis thereof in your petition or not?
yes, my lord, if,
No, not in Dharam Singh. In your petition, have you made those
yes,
submissions?
essential, my lord. His work is essential.
Have you mentioned it?
Yes, there, my lord.
And therefore, non-creation of a sanction post
I have. stated.
amounts to violation of a, have you made it?
Yes, I have mentioned.
Let us then develop the law further.
Catchword here, catchword here is that whether a person is working, is the nature of job is of perennial nature. That is the.
This is perennial.
Yes, that is definitely.
This is perennial.
Yes.
Because without the sweeper, it cannot happen. But you have a policy as regards this, but that policy may be subject to judicial review also, taking into account that this is required. So I think it will have a far-reaching consequences if it is decided. And I'm kind when it comes to Guwahati High Court against Guwahati High Court. Yes. Issue notice making it returnable on
And
4th of December.
yes,
Miss Yuda, the learned additional senior government advocate, accepts notice on behalf of the respondent number 1 and 2. As regards the respondent number 3 and 4, Mr. H.K. Das, the standing counsel of the Guwahati High Court, accepts notice. The case of the petitioner herein is that the petitioner was appointed in the post of a sweeper by an order dated 16/5/2013 by the District and Session Judge Dorong Mongoldoi. And the petitioner continues to render service as a sweeper in the said establishment. It is the case of the petition, further case of the petitioner, that the petitioner have sought for regularization. However, such requests have been not considered. And it is under such circumstances the petitioner has approached this court. The learned counsel appearing on behalf of the petitioner had further submitted that the job done by the petitioner is perennial in nature and it would require and has to continue and the respondent authorities have been totally unjustified in keeping the petitioner, in engaging the petitioner as a temporary employee for the last 12 years. The learned counsel submitted that in view of the judgment of the recent judgment of the Supreme Court in the case of Dharam Singh versus
State of UP and another,
State of UP and another, reported in
2025 SSC online SC 1735.
comma, the non-sanctioning of the post is of a post in non-sanctioning of a post and continuing a person, an employee as a temporary employee for a decade. Non-sanctioning of a post, rendering perennial service, and continuing the petitioner herein as a temporary employee amounts to violation of Article 14 and 21 of the Constitution, and as such, subject to judicial review. He therefore submits that this is a fit case wherein this court may pass appropriate directions for the purpose of consideration of the case of the petitioner for regularization. The respondents are directed to bring on record their stand by filing the affidavits on or before 1st of December 2025.
Much of it.
Anything?
They were supposed to give the calculation today. They were supposed to give the calculation today. Last time they
We
did.
have calculated. It goes beyond 25 crores. So my lord, it has to be sent, there is a committee in the cabinet which look after this MSME affairs. We have submitted a communication to the chief secretary from the chief engineer. Lord, will kindly pay us this.
It is your fault.
This is only dealing.
All the interest has to be taken from the salary of these people.
Candidly, I have to admit one thing, the last time when Mr. Thakur appeared, instructions were that whether these negotiations will be sent, the negotiations will be sent to the highest authority for a decision. But somehow, how he stated that it will be calculated, we don't know, because now we are bound by that order.
That was what was said.
What?
Mr. Thakur stated before this honorable court that calculation is going on. Actually, calculation is not going on. Actually, calculation, we have not reached to that step now. We have just negotiating and it will be sent to the highest authority whether it will be accepted or not. But since that statement was made, Mark, that we are bound by the order now, so we have calculated. And they have-
I mean, just.
No, negotiations.
Thakur went the step ahead.
Mr. Gogoi, you have to understand. The negotiations were going on, there is no quarrel. And on the basis of the negotiation, the arrangement, it was decided that up till 2019, they will be taking as per the MSME rate. And further, as regards the remaining period, they will be taking 12%.
12% simple.
This was the negotiation. Now thereupon, you were calculating the amount so that the same has to be placed before the competent authority. What is wrong in the submission of Mr. Aibot?
No, there's a catch, my lord, because at that stage, my lord, we had not reached that calculation part. His instructions were very clear, just to appraise this court that that negotiation will be acceptable or not. We'll go to the authority, then we will calculate.
But the
It
point.
went a step ahead.
No. Calculations are being made here, arrived at, that a negotiation has been arrived at. On the basis of which he is taking appropriate steps. That is his submission.
Actually, ma'am,
He therefore seeks a week's time for the purpose of providing the details as to how much amount the PHC would be paying to the PCA in the 3 week petitions. That's all. He never said about the thing.
No, my lord, that is the issue. The negotiation part actually, we have to get it first accepted, the authority
And
takes.
why have you not got it
negotiation.
accepted? Then why have they not got it accepted?
First negotiation has to be
Mr.
accepted.
Gogoi, if you want, no, you are also Mr. Gogoi. I can pass an order, dismiss, allowing his, her petition, then you, because the problem which this court found is that if I allow the repetition, that the liability upon you will be huge.
And this way, Lord,
And taking into account that, I passed that order, giving a chance. You see, my earlier order,
Fine.
it was passed. This court, while hearing the learned counsel appearing on behalf and taking into account the implication of huge amount of interest and had inquired with the learned counsel appearing on as to whether there is some sort of settlement can be arrived at so that the interest portion could be reduced.
Fine.
This is the order which have been passed on 9/9/2025.
My lord.
This is the basis on which otherwise there is no way out.
So now since we are.
What
bound by
you
the
were,
contract,
you see your contention, what you have taken is what? Then let them go again before the MSME
Fine.
and get an award.
There we have to deposit an amount. If they go for that also, we have to deposit something, 75%.
75%.
But there is a contention, but just for, I also want to weigh out. As, we are not clear this unit is a micro, small or medium. Because if lordship goes to definition N perhaps, 2N. And then medium is not there now. Only small,
We have some,
small and micro is there.
we have,
Then units, my MS is small industry. So
it's a small industry.
no, my lord, it's not very specific, medium, small or micro.
My lordship, no, this is a ridiculous,
No, I'm just saying that's the reason I started with.
that's a ridiculous proposition they come up now.
It's too late, my lord, I understand.
I think lordship, this thing just buying time and creating problem for acting against industrialization. That's,
Now then I think you take the decision from this court as you are not going to do it. Take the
Since, my
decision,
lord,
we
we
pass
now
an
have-
order.
No, my lord, with due respect to order passed by the lordship.
No, we'll pass the order.
Since, my lord,
I gave you an opportunity for that. Now, if you don't want to take it, don't take it, no
all
problem.
of this going on, my lord, since we have submitted the demand, the chief engineer, regional secretary, to do the full.
lordship, every unit is set.
Before the minister and also the finance authorities, whether we are in a position to cater to this huge amount.
No,
You have
you are
to-
not. It is not that you are in a position to cater to the amount or not, that is not there. You have assets. Sell those assets if you don't. But the fact remains that it is absolutely your fault, as of now also not paying.
Le-
Every day delay, it is an 18% interest. 18 more than that.
More than that,
7% into 23. 3 times, na?
3 times.
Then 21%. 21% is a huge amount
With quarterly rest, lordship.
with quarterly risk. It is compounded.
It surpasses annual budget of few states.
Then
So my lord will.
that is why I say
We are
that
bound by the
look
lordship's
out
order
into
now,
the-
since it's.
No, Mr. Gogoi, you are not appreciating the point properly. You are now trying to put the blame on Mr. Aibot Thakur.
No, I'm not blaming him.
Absolutely, he said this or he said that. We are not concerned to that. But the fact remains that the council never did so. Mr. Aibot Thakur never said that. He said that yes, we are required to make the calculations only to that effect. But the fact that there was some negotiation going on
Yes.
and
that's-
have arrived at to the fact that they will be taking into account the interest as per the MSME up till 2019, and for the next 5 years it is only 12% without quarterly rest. This is the negotiation amount. Then
Since, no, I'm not disputing that with. Now, since we are bound by lordship's order, we have submitted. a
it is not
calculation.
the bound by my, if you have any problem, you go to the division bench against that order. I have nothing to that effect. But remains out there. Then
what
if
I'm
you are,
asking-
if you are trying to put the blame on this, on the question of negotiation, take the judgment from the court. Take the judgment from this court. We'll pass the judgment And thereby you will be liable to pay as per whatever it is, as per that section 17. And then don't say anything later on. We gave you the opportunity, you did not.
I want some further opportunity because this has to be vetted by the highest authority because finance implication is too high for us to handle. This has to go to, there's a cabinet, there's a committee of the MSME of the assembly. It has to be placed there. That chance.
But it doesn't show that you have, the competent authority has referred to that.
No,
particular thing.
Go, my lord. First, it go to secretary placed before the chief secretary placed with the minister. Then the process comes in.
How long?
So that means there will be a continuing payment of interest. Is this the manner? You are not acting fast.
One of the things take time and issue is like these assemblies being convened in the month of November.
So,
And perhaps there is a committee by the MSME and there is a committee that has to give approval for
There
payment.
is no committee, Mr. Gogoi. It is the state financial committee. That particular committee is there, which is being chaired by the chief, by the finance minister. And under
MSME is a separate
that
matter.
committee gives up all these details. That day, where is Miss Yudas gone? Yudas has duly provided, day before yesterday, I was taking up another. They are going to have it in a recently. In coming weeks, they are having that particular meeting. Why, and it is required that the competent authority has to forward to that committee. We have not forwarded also.
No, it will go, man.
When?
It is just prepared, so it has been just sent.
Then,
It will go.
the contents of this letter is otherwise not so. You say that the petitioner has requested.
Yes, man, let's see.
It is not the petitioner who has requested.
They have
Petitioner has not requested that.
the annexing documents. Man.
Lordship, they asked us to give a calculation, we gave the calculation. And as per the calculation,
It was mutually agreed as per the MSA would be paid. It was mutually agreed. See the communication by the petitioner. The next page.
Lordship will grant us some time. I'll speak to the chief secretary, additional chief secretary regarding this, what they are contemplating basically.
The letter which has been written by the chief engineer is wrong. The contents of the letter is wrong. And what has been submitted before this court is wrong. You say that the petitioner is asking for this.
we are not-
Petitioner is not asking for that. Petitioner herein is asking for the entire amount.
absolutely.
It is at the request of this court, the petitioner has lowered down their demand and has been negotiating with you. The petitioner doesn't have anything to that.
Lordship, let the chief secretary appear and apprise the court what has happened. Let the chief secretary appear and apprise the court. Apprise the court what is what, because this
It has not.
this is going on. This is going on
I'll
for
ask the-
months and months and months. Let there be a personal appearance.
Now, your letter which you have written, the very cleverly drafted letter. This type of letter which you are giving it to us means you are trying to play with the court. You say that the petitioner is asking and on the basis of which you are making the calculation. See the language of your letter.
Well, perhaps this is that drafting is based on.
No. Drafting is very clever drafting.
They're playing tricks, Lordship. It's clear, out and out clear. They're playing
And
tricks.
they are not interested. We take
They-
it up for disposal.
Or let the chief secretary appear and apprise before the
No,
court.
no, so we passed the judgment. I gave them the opportunity. They failed to take that opportunity. We'll take it up now. We'll dispose of
Then,
them
of course,
and pass on.
Then the lordship, they'll go and appeal, then they'll go to Supreme Court. This is what.
Let them file an appeal. Let them file an appeal, whatever may be. Them file an appeal, we take it up.
Well, I have been apprised to seek 4 weeks, another 4 weeks, last 4 weeks.
For what?
Because what is happening, what I'm trying to point out.
No, you are pointing, no. Mr. Gogoi, first of all, the contents of the letter by the chief secretary, chief engineer is wrong. He has not properly given that letter. He should have said that this was the negotiated arrangement. This is why the petitioners are writing. What do you say?
What I was trying to point out from the initial stage, my lord, of this proceeding, that it was never arrived at. It was still in a negotiation.
What negotiation?
It was earlier, it was on a negotiation that we had asked them to give the standard bank rate prevailing now. Then we'll be sending it to the highest authority. If they give a
No, that is for the purpose of calculation. I'm not on that. But the fact remains that as per the act is very clear. What will be the rate and it will be 3 times. The act is clear, section 16 and 17. And they have said that, okay, we forego all these things and we'll take only 12% for the remaining period. That is what they are saying. And where is the question of bank rates? Otherwise, they are giving up their rates, the calculation from 2019 for the last 6 years, they are giving up their rights in respect to this for the last for around 8%.
Lordship, we,
8-9% they are
I
giving
think we give out each company about 7-8 crores we are giving up.
9% they are giving up. So 9% giving up for the last 6 years. Just tell me. How much it would be? With 9%, it will be double?
Well, it should be
Yeah.
double. But as of now, I have been advised to seek 4 weeks.
For what?
Father,
Because your like your thing is not proper.
also will consider the dire straits we are in now because.
That is why I considered and
I just-
therefore,
Lordship-
after arriving at, I passed that order initially and then after arriving at, I said, if I pass an order, it will have, heavens may fall upon the PHE department and the state of Assam. And therefore I said that can it be negotiated? And therefore I asked both the parties to negotiate. Because if I pass an order, it will have a very huge amount. And with this huge amount, then you are in trouble. Look at
Yes.
the thing that in respect to other industries, you have no problem in paying. But in respect to the petitioners, you have a problem. It is evident from the materials on report. If I pass those type of aspect and observations and pass an order, yes, you may have a right to file an appeal. You may file an appeal, but nobody is going to stop.
Yes, it will keep on accumulating.
And it will keep on accumulating. So there needs to be brought a closure to this. But for the fact that you have not made the payment, it is your look. Otherwise, we take it up on that. You cannot come up with this 4 weeks, 3 weeks and all. It was apparently the meeting which was held with by the petitioner was not with the chief engineer.
No.
It was held in the level of the additional chief secretary.
My lord.
Then an additional chief secretary was very much present and there was negotiations, 1 round, 2 rounds of negotiations which was going on and which was duly intimated. And therefore I said that, okay.
So considering.
But
their
now-
efforts,
But what is now being written by the chief engineer doesn't,
We'll advise him.
this is not proper.
Well, we'll advise him. We'll advise him to take recourse.
You,
to
as if
proper
you are saying it out here, you are, as if you are mentioning that High Court has stated all these things. Then you say that the petitioner is making a request for payment. We have therefore provisionally made this thing subject to approval or not. This is what is the language used.
Yes, last concluding line. Your Worship.
Eh?
So, see, we'll advise.
And then you are now putting the blame upon Mr. Aibot
Well,
Thakur.
I'm not putting
Absolutely.
blame. I'm not putting.
No, Mr. Gogoi, this is not, you may say all these things before any other court, not before me.
Right.
Because I know that the lawyer out there, he never said to that effect. He was in fact saying that there will some more time is required to go into this. We are looking into all these things. Then I put the question to him. What is the time required? So there will be requirement of calculations and all these things. So then I said that in this AI world out here, do you require weeks and weeks for the purpose of getting the calculation done? But this, what you have done is not. Therefore, there is no word out here as regards the calculation. You see my order in 1510. Where is the? And on the basis of which the department is taking appropriate steps.
Well, I'll still seek 4 weeks.
For what?
This course.
No. This is
Corrected. This has to be corrected. Because if
To
something
correct
is-
this
if
letter.
the- if
correct,
something is
corrected
due-
next week. Next week, write a proper letter and then give it to us. Next week. Then we will see whether 4 weeks is to be given on.
But
And
what,
that too by way of an affidavit, not by this type of language.
Fine.
If you do it by way of an affidavit, then it will be done. Otherwise, nothing. I understand that you cannot get the money on your own. It has to be put before the, what is that name? SF? State Financial?
no.
You are not aware. There is a state, where is Miss Yudas? Call her. When there is an amount beyond what is mentioned in the budget, this amount has to be then cleared by a particular committee.
Fine.
I understand that. But this is not how you ask for
I
it.
will advise. Finance is a serious issue, my lord. What has happened?
Finance is not a serious issue. You have no problem in making payment to others. This is on record. You have
Some,
no problem in making payment to the others, but you have a problem as regards payment to the petitioner. Otherwise, you take the judgment. Let them go wherever they feel that. My duty is to deliver the judgment. Whatever you do, that is your fault. Appeal file, not
I don't actually want to, I don't want to take that of panic order. If that order is passed in that presence of additional advocate general, that if that order is passed in presence of PN Goswami, my senior PN Goswami,
Mr. Counsel, Mr. P.N. Goswami has not appeared before the court. And what is the status of an additional advocate? Generally, just a senior government advocate.
no, that's.
No, as per in the constitutional provision, I'm not concerned with all these things, who appears or not. The fact remains out here that in this matter, initially when the matter was taken up, Mr. Aibot Thakur appeared, this court had duly heard the matter. And upon hearing up, when it was found that the amount would be phenomenal, this court thought that can a negotiated settlement can go happen? No concern.
So my.
You are not agreeable, not agreeable.
Lordship is fixing it on next week. Fixing it not next week with affidavit, for affidavit.
Affidavit next week.
But lordship, some kind of progress has to be made also.
Affidavit next week. What is the progress of? That is the affidavit next week. We'll see then what orders can be passed.
Next week, like this.
Wait.
It's Special Standing Finance Committee.
Huh?
Special Standing Finance Committee.
That special standing finance committee. So this, when it is outside the budget, then it has to be brought within that amount thing and so that approval can be given for the financial sanction. You cannot have a financial sanction without that approval. Isn't it?
Finance department is also awaiting a report because we have informed them, but the report has not been furnished. So
That is why they are delaying it, right, left and center. I think best part is the judgment will help you.
lordship was once along with the finance consultation with the finance department is
No, the letter which has been written is every day. Right.
Next week. A date may be fixed.
Next week. Next 30th. 30th, we take it as the first item. You
Lordship,
file your affidavit. I'm telling you, if you don't file an affidavit, we'll call the additional chief secretary.
Well, no,
Date
let me hear the date properly.
An affidavit to be filed by no other person than the additional chief secretary. And we are not concerned with the chief engineer.
special additional,
Your chief engineer has no business out.
special
Because
chief
this court, on the instructions directed the chief, you see, the additional special secretary or what is the name?
special chief secretary, na?
Ah, that's one. Let that person-
Special additional chief secretary,
His special chief secretary.
special chief secretary.
Yes. Let the affidavit be filed by him, not by all your people. Additional chief secretary.
Special chief secretary.
Where, I have mentioned it in some order. They will appear, yes, with the special chief secretary of PhD. No, my order was to appear before him, no?
Yes, Lordship.
Yes, perhaps I was there.
Special secretary PhD in the matter, he upon instruction submits that on so and so at name. So this affidavit be filed by the special secretary PhD. Yes. But Mrs. M. Hazarika, the learned senior counsel, appearing on behalf of the petitioner, Mr. D. Gogoi, appears on behalf of the PhD. This court duly heard this matter on 9/9/2025. And upon hearing, it was found that the stand which had been taken by the respondent, PhD, to deny the petitioner the dues in terms with the medium, micro, small, medium enterprise development Act 2009 was not tenable. However, while taking up the matter, it was found that if the amount is directed to be paid in terms with by applying section 16 and 17 of the Act of 2006, it would have a huge implication on the aspect of interest. Considering the above, this court, upon hearing the counsels, inquired as to whether the matter could be amicably settled so that the interest portion could be reduced. The senior counsel for the petitioner submits that the petitioner had submitted that the petitioners in the three petitions were not adverse to us negotiated settlement. Considering the above, and the standing counsel appearing on behalf of the PhD further stated that the state counsel said advise his client in that regard. Accordingly, this court directed the representatives of the petitioner would meet the special secretary PhD accordingly, the court directed the petitioner, representatives of the petitioners to approach the special secretary PhD on 15/9/2025 at 2 p.m. On the basis of the instructions so provided to this court. The matter thereupon was listed on 19/9/2025. Wherein it was apprised to this court that there were certain deliberations going on between the petitioners in the batch of writ petitions with the special chief secretary of the PhD. And there was a likelihood of an amicable settlement. On 15/10/2025, when the matter was listed, it was submitted at the bar before this court that a negotiated form of settlement had been arrived at to the extent that the petitioners in the batch of the petitions would be paid the dues in terms with the MSME Act of 2006 up to 31/3/2019. And thereupon, the petitioner would be foregoing the interest rate as per the Act of 2006, 16, 6, as per the Act of 2006, but would insist for the period from 1/4/2019 till realization. And the petitioners would be paid 12% only per annum. On the basis of the said submission, it was also submitted by the learned counsel appearing on behalf of the PhD department that some time is required for the PhD department to take appropriate steps so that details can be provided as to how much amount the PhD department would have to pay to the three petitioners. Accordingly, the writ petitions were directed to be listed today. When the matter was taken up today, Mr. D. Gogoi, appearing on behalf of the PhD department, for the first time before this court, took initially a stand that the earlier standing counsel of the PhD department ought not to have stated that the PhD department were making calculations as to how much amount was payable. The learned counsel further submitted, learned standing counsel further submitted that in view of such stand being taken by the learned standing counsel, the PhD department were compelled to make the calculations. It was further submitted that the chief engineer, PhD department, have written to whom? Written to whom?
The secretary, my lord.
To the secretary.
Pursuant to applications filed by the letters filed by the petitioners themselves, my lord.
No,
They have written
petitioners, no. Petitioners are not submitting anything.
My lord, can you see the letters, man? They have written chief engineer.
When were these letters written?
They have written on 2010. 2025.
Madam, what is wrong with your clients? Why are they writing when the matter is being taken up by this
I know,
court?
Lord. No, Lordship, not like, not this.
Okay, leave this matter before any other bench. I'll not-
No, Lordship, it's not that. I'm very sorry,
It is
Lordship.
not done. You should
Lordship,
not have, I'm not going to take up this.
No, Lordship, this is
This is the
not.
matter. Taking into account the conduct of the petitioner, this court is.
No, Lordship, I may just point out.
Absolutely no.
No, Lordship.
Why
this-
on earth have they written all these letters unnecessarily when I'm taking up the matter on day to day?
Because Lordship, they asked us to give the calculations. The chief engineer
I'm not
asked us,
concerned with the calculation.
Chief-
Why have you written these letters?
because the chief engineer asked us, Lordship. You write a letter, give a letter to us.
Where's your letter? But the chief engineer has asked you?
They asked us verbally, Lordship, they'll never
No,
give us.
there's no verbal.
They'll never give us, Lordship. Meeting held on this, Lordship, we wrote pursuant to that, Lordship. Pursuant to what they said. It's not at our own.
No, when the matter is being taken up, why are you writing?
No, Lordship.
So let this matter be taken up by some other judge.
No, Lordship, I'm extremely sorry.
No,
Extremely
I'm not
sorry.
going to take.
Lordship,
Sorry.
I'm extremely sorry.
No,
Lordship, this
I'm
is
not.
this is a misunderstanding.
Madam, I have nothing to say against you, but your client's conduct is not.
No, Lordship, this is actually
This is
because
not-
they have asked us, Lordship. We submit because they have asked
Why
us.
are they writing letters when this court has been insisting on that?
Lordship, I'm sorry, it's a mistake there. Lordship, at least once, Lordship, may pardon this time. Lordship, just this time.
No.
Lordship,
No, no.
just.
This type of matters I'm not going to take. Unnecessary, this type of.
Lordship, no, Lordship, what you're talking.
But second matters wrote to the chief engineer, where the department is there for.
No. They had asked us, Lordship, to write to there to give a letter. The chief engineer said, Amar Kubida Hobo corridor Pothai.
No, why are you doing it?
Lordship.
Why are you doing it if that be so? When the matter is being taken up,
No,
if your
Lordship.
client does not trust your instruction or your advice, then why should this?
No, Lordship, that is because they wanted the calculations. I'm very,
Why? Then why are you providing the calculation? It is nothing to do. You may provide the calculation, but why are you writing? Have you written in those letters that you are doing it as per their verbal communication?
with reference to the Honorable Court's direction and its response submitted, Lordship, I pursuant to the meeting held with them, Lordship, I have not done it on my own because they asked us, they asked us, Lordship, just for this once, I may be forgiven, Lordship. Just this once,
This
Lordship.
type of matters I should not.
Lordship, this once may be forgiven, excuse once. Lordship may fix it on a later date, but this time it may be, because when they ask us, Lordship, what can we do?
No, you can very well say that the matter is before the court.
Yes, Lordship.
Then
but-
if the petitioners want to have something out there, why should we give anything to that effect?
Though they said that you put it in writing, because what has happened, they have not made the minutes. Minutes were not done. Minutes were not done, Lordship, and so they asked us, so it's easier for me to do it. That is what is, Lordship, my clients are, the clients are also in a fix. They are also in a fix. They want the money. They have the PhD, apuni bisarok, apuni korok.
Okay, we do one thing. Take up the matter for final disposal. We'll dispose it.
Absolutely.
I'll pass the judgment. Go ahead. Do whatever you feel like. We are not concerned with the negotiation. Let me define this, allow your petitions.
Okay.
Pilot, can I take a small break?
No, we'll fix a date.
Please, no.
We'll fix a date for final.
Pilot, you're disposing out of a date.
No, I'm disposing it. No.
Pilot, I just want a break. Just a small break for 1 minute. Here's-
Let me write down the. Okay, madam, you argue.
Please, the Lordship. Lordship, what had happened was we were given orders for supply of pH of pipes. we were given orders for supplies of pipes. We are registered MSME unit. Our registration certificates have all been annexed with the writ petition. It's annexed. We also have the Yudham registration, which is necessary under the MSME Act. And we were given orders for supply of various pipes by the PHE department. And we fulfilled the supply, we fulfilled all the requirements as per their order. And Lordship will find, but despite our fulfillment, we were not given the. But despite the fulfillment, we were not.
I think at first I didn't get us. My losing.
They came asking us to bring writing. That's not the way they asked us. That too, Lelva. Check the letter, check the letter. Very good.
Madam, we do one thing, we'll have it on 6th for final disposal. Absolutely. Holding that the negotiations have failed. Because if I don't give an opportunity, he may take up the plea later on before the division bench, saying that this court was not fixed today for the hearing.
Absolutely, absolutely.
So.
6 is
let
fine.
us- But I'm very displeased with the conduct of your counsel clients. This shouldn't
Lordship,
have been done.
that should
And
not.
therefore, it would not be proper for this court to further pursue with the negotiated settlement, taking into account that you are going behind the back of the court.
No, Lordship, it was not.
We'll go as per merits.
I'm extremely sorry, but they are
Still not
Lordship.
done, but next time onwards, this shouldn't happen. If it happens, it's not going to take.
Because
It is seen that,
they were all.
no, heard Mrs. M. Hazarika, the learned counsel senior counsel appearing on behalf of the petitioners in the present batch of petitions. And Mr. D. Gogoi, the learned standing counsel of the PHE department. This court had fixed the matter today for providing details as to how much amount the PHE department would be paying to the petitioners in the 3 writ petitions. This order dated 15/10/2025 was on the basis of an order passed by this court on 9/9/2025, whereby this court gave an opportunity both to the petitioners as well as the respondents in the PHE department to arrive at a negotiated settlement. Given liberty, gave an opportunity to both petitioners as well as the respondents in the PHE department to arrive at a negotiated settlement. However, from the instructions so produced before this court by Mr. D. Gogoi, the learned standing counsel of the PHE department, it appears that the claims as regards the negotiated settlement, as mentioned, as was submitted before this court dated 15/10/2025, does not appear to be correct. Considering the above, as there is, seems to be no scope for any negotiated settlement, this court would be taking up for a matter for final disposal on 6/11/2025 at the top of the list. Yes, what is this?
May it please your lordship. In fact, my lord, your lordship has heard this matter earlier also. The issue involves is, my lord, is that my lord, an NIT, my lord, an NIT was floated by the railways. In response to this NIT, my lord, we had given certain conditions, certain deviations from the NIT. This is number one. And number two, my lord, when we submitted the deviations, we said, look, as far as we are concerned, we are ready to do this work, provided A, B, these two conditions we need. They have issued an acceptance letter without considering my deviation. This is one. And on the top of that, they have changed the condition of the NIT in their acceptance letter. Thereafter we said that since you have not considered my deviation and you have changed the condition of the tender, therefore this cannot be treated as an acceptance, but it can at best be treated as a counter offer, which we reject. They issued purchase order and said, if you do not do the work, we are imposing penalty of 45 lakhs on us. We are aggrieved by that. My simple issue is, I'll just show to that one. My lord will kindly see. First, I will show that whether there is a provision of giving such deviation statement or not. I'll have to satisfy the court that whether there is any such provision. My lord will kindly see page number 39.
Page 25 is the notice inviting tender.
Page 25 is the notice inviting tender. I'm just taking a lordship to the relevant part.
What is the notice inviting tender for?
This is, my lord, this is for
Manufacture and supply of elastic.
yes,
rail-
elastic clip marked 5. These are, my lord, normally, my lord, these railway tracks, my lord, 2 railway lines are joined by a clip. These are manufacturing of the clip because we don't get that much long railway lines. These are in, of certain length. These are joined together with some clips, elastic clips. These are those clip contract, my lord. Now, your lordship may kindly come to page number 39. clause number 26, deviation clause, your lordship, is there, my lord? In cases intending tenderer desires to quote deviation from the tender condition, the tenderer should attach deviation sheet along with his offer and should indicate the cost of withdrawal of each such deviation sheet quoted by him. In cases where the firm does not submit any deviation sheet, it will be taken that the firm has accepted all the terms and conditions as per the tender condition. This is one. Number two, my lord, we'll kindly come to page number 54. My lord, this is also a part of the NIT tender condition. Instruction number 1.1. The tenderers are requested to carefully go through this instruction and all the conditions as mentioned in para 1.3 and 1.4 appended herein below. By submitting the quotation, they undertake to abide by all types of condition at para 1.4. The tenderer's digital signature on the e-tender form will be considered as their confirmation that they have read and accepted all the conditions laid down in the document as well as tender schedule comprising of techno-commercial offer from including such and such, my lord, and financial offer from unless specific deviation is quoted in the techno-commercial offer form. Now, my lord, since the tender gives an option of submitting a deviation sheet, in terms of that, my lord, we have submitted our bid with a deviation statement. Your lordship will find the deviation statement at page number 107. This is me, my lord, Kalimata Vyapar Private Limited. This is commercial deviation in specific condition against tender number such and such. These are the two deviation. We said that you need to include these two. Delay in inspection. If there is any delay in inspection beyond the 7 days from the date of submission of our call, the delayed period shall be counted to railways account and DP should be refixed. Date of completion, that is DP, should be refixed accordingly. This is one deviation we wanted. Number two, non-availability of raw material by Rashtriya Ispat Nigam Limited. In case of non-availability of raw material from NILL, during the currency of the contract, since our offer is based on the approval of such and such as approved vendor, I'm speaking these technical things. And if there is any delay for execution of the contract, such delay will be railways count and DP should be refixed accordingly. We shall not be able to supply the material within the DP until or unless the raw material is manufactured and supplied by such and such on regular basis, since ERC manufacturers are only dependent on such and such for procurement of the raw material. So, my lord, my very purpose is to show that we have submitted a deviation statement. Now, my lord, the next, your lordship may kindly come to, perhaps that will, my lord, that will suffer. Page number 34. My lord is there at page 34. My lord will kindly see clause number 25. Price variation clause. In some tender, it is also called as price escalation clause, my lord. Price variation clause. PVC formula for various track fitting with base year 2011-12 as issued by Railway Board white letter number such as R as under. Now, my lord will kindly read the second paragraph. Any offer with different PVC formula or quoting different base month or linkage with different indices or fixed rate, etc., as compared to PVC formula provided in the tender will be summarily rejected. But what it essentially says is that for the price escalation, they have a certain formula. So in my tender condition, in my bid, if I give any formula which is not in accordance with the tender notice, then it will be summarily rejected. Now, my lord, what is the formula for calculating the PVC? They have given in their tender. Your lordship may kindly come to page number 38.
Given in 25.1.
Pardon, my lord?
25.1.
25.1. My lord will kindly come to page number 38. For all types of material, it is at page 38. Now, here is my entire case is at page 38. Now, my lord will see. This is all types of ERCs, elastic rail clips. ERC, it is the acronym for elastic rail clips.
Then, Doctor, are you relying on clause 25?
Yes.
For the purpose to say that your bid ought to have been rejected?
No. What I am saying is this. In their tender document, this page 38 is a part of their tender document. In their tender document, they give a formula for calculating the PVC. Say, for example, the formula is X. X formula will be adopted. Now, I gave my bid. In their letter of acceptance, they have changed this formula X and made it Y. Is it permissible? That is what I want to show. This is a part of their bid. If your lordship juxtaposes page 38 with page 54, if I am not mistaken, it is 54. It has to, no, my lord, it is 110. 109 is the letter of acceptance, 110. 109 is my letter of acceptance and 110. The formula which they have given in their acceptance letter. If your lordship juxtaposes, your lordship will see that they have changed the formula in their letter of acceptance. How it can be, my lord? Because A1, wholesale price index for input stealing as prevalent during the month just preceding the month of issue of the call letter for inspection. And here they say as prevalent at the time of 10 days prior to call inspection. Not only for one item, for all the items they have changed the formula in their while issuing the acceptance letter.
Then,
So therefore, my lord, when they issued this acceptance letter, we said that it cannot be treated as an acceptance letter. It can at best be treated as a counter offer, which we reject. I'll show that, my lord. So they issue me this letter of acceptance by unilaterally by changing the condition of the tender. And my lord, it is their condition that if there is any temperament with the PVC calculation formula, then a tender is liable to be rejected summarily. Now, my lord, page number 112, they issued this letter of acceptance on 1st of April. Within 3 days, on 4th of April, we write to them that, look, it cannot be, we cannot consider this as a letter of acceptance. 112, my lord will see. Your above referred letter mentioned reference is not a letter of acceptance, it is a counter offer. Hence, it is rejected.
but
Yes.
in the order which has been given to you,
Yes.
that is at page 115,
115. 115 is the, yes, this is,
the price variation clause.
yes,
This is as per the letter of acceptance,
yes,
not as per the tender.
no.
Then,
This is my case, my lord. That, and then, my lord, when I refuse at page 112, that this cannot be, this cannot be treated as a letter of acceptance, but it can at best be treated as a counter offer, which I reject. At page number 12, I have categorically said, your 112 is my letter. Your above referred letter mentions such and such. It is a counter offer only, hence it is rejected. They insist that I should complete I should take up the work and complete the same. And then there has been correspondences in between. I'll skip all those. Finally, my lord, at page 136, they terminate and give a penalty of 10% of the tender value. 136, I am aggrieved by only the last paragraph. 136.
yes,
My lord, only one line, my lord, my lord, before parting, my lord. Now, my lord, while submitting my bid, inadvertently, the GST rate I had quoted 4%. And immediately thereafter, I said ki this has been inadvertently written at 4%, it ought to have been 8%. There is a typographic error. Now, in their counter affidavit, they are placing the blame on me that all these are eyewash, this deviation not being made a part of the letter of acceptance, or this formula where there is a change. These all are eyewash. Actually, since I have quoted 4% inadvertently, therefore I have filed. This is essentially what they have prayed in their letter, in their affidavit.
So when did you say about 8% and 4%?
My lord, will kindly see that to page number 108, my lord will see immediately after submission, even before issuance of the letter of acceptance, immediately after I submitted my bid on 27th of December 2021, which your lordship will find at page number 100. 27th of December 2021, I have submitted my bid at page number 100. Immediately within 2 days, on 30th 12 2021, at page 108, I said that, see, I have wrongly quoted the GST as 4.5%.
When is the date of letter of acceptance?
Letter of acceptance is 1st of April 2022, after 4 months.
And when did you write the letter?
My letter 30/12/2021.
No. Against LOA.
Acha, against LOA. Against LOA, I have written and 4/4/2022 within 2 days. And purchase order they have issued on 27/4/2022.
Termination?
Termination and impugned 18/7/2022. My only grievance is imposition of that penalty. Rest work, whoever they want, they can get it done. That's my simple case.
Yes. Especially the particular GST melody, usually 4.5.
But where is the conclusion of the contract? When did the contract conclude?
Because actually, completion of the contract.
Conclusion of the contract means when did you have a contract? You had made an offer. When you send the bid, you are making an offer. He submits his proposal. This is it. You say you either accept it. You can accept it.
Yes, sir.
That we accept the proposal. Did you accept those two clauses?
There is not, my lord, this record speaks, my lord, there's what, letter, something was different, my lord. And it was different, my lord, some letter, LA was received, my lord, what my learned friend is true, my lord. This, super, clause 25, my lord.
Huh?
PVC price.
Price variation. Price was, my lord, that is meant different.
No, not the price variation. I'm not on the price variation. Now, did you accept? Let us see your letter of acceptance. Where is that page?
Page number, my lord, letter of acceptance.
110, man.
110.
Sorry.
No,
That is
109.
109.
109 is the letter of acceptance. Now, in the letter of acceptance, did you mention anything about statutory variation clause? Statutory variation clause also, and so after submission of no claim on account of statutory variation of listing taxing unless the tender has been clearly indicated in his offer. Tender is classified as goods by the Board of Payment. Now, what happens to his price, the deviation clause? Is it included in your letter of acceptance?
Yes, my lord.
Have you accepted the deviation clause?
So, but this is quite small, I believe, I will take on also asking.
No, Mr. Mehdi,
Yes, I understand.
I'm asking you, I don't require to look into these pleadings. Your affidavit starts and finishes
Yes,
without much.
yes, that is.
But the question I'm asking you is you are arguing for the railway. did you accept the deviation clause in your letter of acceptance?
Madam, it is the paragraph 7 speak this much only, madam. So this, I cannot go out of this affidavit, madam. That readers statement in paragraph number 5 of the replacement document, which is the respondent authority agreed to this deviation and considered for placement of order by person. Paragraph 7. So I repeatedly ask.
So therefore you agreed to the deviation.
Yes.
Therefore, okay, now therefore you have agreed to the deviation. Now, is it requirement that when you agree to a deviation, in the letter of acceptance, you have to mention that you agree to the deviation?
And it is not there, madam.
Hmm?
Letter of sentence, madam, this thing, madam, not there.
So it will be there in your records that you have agreed to the deviation.
Maybe, madam, but I have to bring produce the record.
Okay, now he has written a letter that you have not agreed to my deviation. What is your reply?
This much reply.
Have you mentioned it in your reply that you have agreed to the deviation?
Yes, madam, and considered for placement of this first.
Let us see your stand in your. Where is your stand? You have written a letter somewhere.
Yes, that letter your lordship will find at page number 124. In fact, here also they have misled and they have misquoted one provision, page 112. 124, sorry, it is their letter. They don't say anything about my deviation.
You wrote the letter on 4/4/2022.
Mhm.
Okay. This is not in reply. Your letter.
Then again, again, I have written to them a detailed reply at
On
page number
12/5.
118.
12/5.
118, 12.5, a
So
detailed
here
reply.
also you do not mention that you have agreed to the deviation.
Yes.
One. Secondly, you mentioned you change the price variation clause.
Yes.
You submit a proposal. Now you submit an offer. You give an offer. He submits a proposal. You accept. You accept and give another offer. Another offer, it is your offer to the effect that this is now the fresh. Then after that, if he has not accepted that, where is the contract? So if there is no contract, where is the question of termination? As well as imposition. Isn't that the issue?
Because law says, my lord, NIT is an invitation.
Okay, what judgment?
2007, 9 SCC, 531.
What does it say?
It says, I'll just read 4 lines. Yes, para 12. Yes.
What is this form of tender? What is a tender?
My lord, a NIT is an invitation to make an offer. It is not an offer. NIT is an invitation to make an offer. The bid is the offer. Acceptance is on them. The moment they tamper with my bid, some condition, then my role changes. He becomes then the offerer and I becomes the offering. Then I will have to accept it. It's
So
when
who becomes the proposer?
my lord, I will use the term offer because that is more akin with because proposer, my lord. I'll put it in this way.
No,
And-
we go as per the Indian Contract Act.
Yes, there is a this proposer and those
So
words.
who will be the proposer in this NIT?
here, my lord, when the NIT is an invitation to make a
Proposal.
proposal.
So
It-
therefore, it is an offer by him. It's an offer by him saying that look here, we want bidders.
Bidders.
These are the terms and conditions. Anybody wants to come, come. He said offer. And in this offer which you are giving, he's giving, you submit your proposal. So as per the contract, there is a proposal
Which he has to accept
which he has to accept.
unconditionally.
Now, your proposal which you have submitted, you said that this particular proposal is that I don't like this clause and these two clauses may be modified. He does not accept that, but puts another clause in his offer, which you have to accept for a contract. formation.
Absolutely. There is no binding contract. That's the issue.
So
So
what is the judgment?
it says when an offer is conditional, because I am the offerer here, when an offer is conditional, the offeree has the choice of either accepting the conditional offer or rejecting the conditional offer or making a counter offer.
You are
But-
not the offerer.
I am the offerer here.
No, he is the offerer. You have the here to accept, reject, or put a condition, which you have done. Then he has to accept.
So the next line reads, the next line says, but what the offeree cannot do when an offer is conditional, because my offer is conditional. When an offer is conditional, what the offeree cannot do is accept a part of the offer which result in performance by the offerer and then reject the condition subject to which the offer is made. That is my case. And on the top of that, my lord, this case is also, my lord, that condition, though they can never change the tender conditions.
See. Contract Act.
Yes, Indian Contract Act.
Oh, you have come without the Contract Act. We should not.
No, my lord, I have the Contract Act, my lord. We have the contract specific purpose, everything, my lord.
Wait,
It's very difficult.
you don't have the contract.
No, my lord, Contract Act, my lord. It's within my reach, my lord. Just they'll get it.
Our first case when I studied law, when I was doing my law in Delhi. So we have it never used to be on the basis of books.
Absolutely,
It used to be on the basis of case materials.
absolutely.
The first case in respect to these type of cases is Carlyle versus Carbon. Where there was an offer made that invitation was given in a big advertisement board out there. Anybody can have. So he submitted his offer. This was not accepted. And then he wanted to rescind and all. So there the concept is there. Who is the offerer? Is him. He's making the offer. Then look here. This is it. You submit a proposal. That is the offering. With a proposal. You are the proposal. That yes, I am willing to do your work. Subject to these are the conditions. And when you do this work, he has to accept it. That is why he is accepting it. Why is he being given the power to letter of acceptance? You have not been given the letter of acceptance. If he was the offeree, you had to give the letter of acceptance, isn't it? If he was the offeree, then you had to give the letter of acceptance. You didn't give a letter. You cannot give a letter of acceptance. The letter of acceptance is his. But he has to abide by what is your counter offer. And if he accepts that, the letter of acceptance will be as per that. Otherwise, he has to again make an offer that yes, I have it, I am not accepting it. Then only there will be a formation of a contract.
My lord, just taking a leave out of what your lordship has said, while attending a class on contract law by Professor Nandiman, I had a PowerPoint presentation where it was explained that this NIT and these billboards which your lordship has referred, these are basically, but I may be thoroughly wrong. I'm just expressing what I faintly remember, my lord, at least 23 years back, my lord, that those NITs and those billboards, those are invitation to make an offer. Those in itself is not an offer. Those are invitation. I am inviting offers. Now, the moment I make my bid is the offer. So if my bid is the offer, then I become the offerer
Then
and he becomes the offeree because he
he has to accept.
accept.
So therefore, it is your proposal.
Yes, proposal.
So you are the proposer.
Absolutely. Absolutely.
So that is why I'm
Yes, yes,
saying
yes.
that he makes an offer.
Yes.
Then look here, this is the particular work which is required to be done.
Yes.
And I want to do it in these are my terms and conditions in which you have to do it. You come up and say that, okay, many people come over, of which you are one, and you say, then look here, I'm willing to do it. This is my proposal. I want to do it. This is my price at which I'm going to do it, which is a part. You need a consideration. That is the price on which I'm going to do it. And further to that, I have these are the clauses which are required. You become the proposer.
Yes.
He becomes the accepted. He has to accept it. Or if he does not, then he has to make a counter offer to
Counter offer.
you.
Any condition if he puts or either he will have to accept
what?
it unconditionally, and the moment he doesn't accept it unconditionally, he puts his condition, then the role changes. He becomes an offerer, I becomes an acceptor.
Now let us see the interpretation.
That's what it is.
Section 2,
Definition,
interpretation.
interpretation.
In this act, the following words and expression unless contrary. Well, one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act of existence is said to make a proposal. This is you. You are making the proposal on the basis of invitation, but he is making. This is an offer I am having. This. Because you don't have, originally you cannot make an offer because it doesn't exist. There has to be something to make the proposal. It is he who is doing it. Where a person to whom the proposal is made signifies his assent thereto. The proposal is said to be accepted, so he issues the letter of acceptance. A proposal, when accepted, becomes a promise.
Promise.
The person making the proposal is you, called the promiser, and the person accepting the proposal
Is the
called
promisee.
the promisee. When at the desire of the promiser, the promisee or any other person have done or abstained from doing, or does or abstains from doing, or propose or promises to do or abstains from doing something, such act or existence or a promise is called a consideration for the purpose of the promise. Where a promise and every set of promises forming the consideration and for each other is an agreement.
Agreement, not a contract. It's an agreement.
It will be a contract when
It is not vitiated by all those vices.
Yes.
Enforceable by law.
Seven,
Enforceable
isn't
by
it?
law.
7. 7. Yeah, again 7 if you come to here.
Yes, acceptance must be absolute.
In order to convert a proposal, that is your proposal,
Yes.
into a promise, the acceptance must be absolute and unqualified.
Qualified.
Be expressed in some usual and reasonable manner unless the proposal prescribes manner in which it is to be accepted. That means with those deviations. If the proposal prescribes a manner in which it is to be accepted and the acceptance is not made in such manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner and not otherwise, but if he fails to do so, he accepts the same.
Which I did by saying that it is a counter offer.
Anyway, because of Mr. M. Datta, we learned some details. Heard Mr. M. Datta.
Doctor, my lord, I'll gladly accept that surname, my lord. with the legacy this surname has in our code.
Huh? Oh, M. Biswas.
But since your lordship says Datta, I said I'll gladly take that surname.
M. Biswas, the learned counsel appearing on behalf of the petitioner. Mr. S.K. Medhi, the learned counsel appears on behalf of the respondent authorities. The present petition has been filed challenging the communication dated 18/7/2022, whereby the respondent authorities, more particularly the respondent number, who is that respondent number?
The tender inviting authority.
The respondent number 3 have terminated the contract, thereby imposing a penalty of 10% of the value of the stores not 10%, thereby terminated the contract with a penalty of 10%. Pusto. For the purpose of deciding the dispute, this court finds it pertinent to take note of the relevant facts which led to the filing of the present writ petition. A perusal of the records reveal that the respondent authorities had issued a notice inviting tender on 28/12/2021 on dated
NIT date is, my lord, 6/12/2021. Page 25.
6/12/2021, calling upon the inviting various bids for the purpose of manufacture and supply of elastic rail clips marked Roman 5 as per RDSO DRG dot number NO 5919, confirming to IRS specifications for ERC T-31-2018 bracket 4th revision bracket close, and as amended up to date of opening. The same notice inviting tender had various clauses for the purpose of the instant petition, for the purpose of the instant dispute. It is pertinent to take note of some of the clauses. Clause 1.1 of the instruction to the bidders stipulates that the tenderers have to carefully go through the instructions and all conditions as mentioned in paragraph 1.3 and 1.4 appended therein. And by submitting the quotation, they undertake to abide by all types of conditions at para 1.4. It was also mentioned that it was also stipulated that the tender's digital signature on the e-tender form would be considered as their confirmation unless specific deviation is quoted in the techno-commercial offer form. The said clause 1.1 being relevant is reproduced hereunder, page 54. It is further pertinent to mention that the tender documents included special conditions of contract for e-procurement of track fitting. Included a set of conditions in the name and style of special conditions of contract for e-procurement of track fitting. Clause 26 of the said special conditions, it's short code SCC, for short SCC. Of the SCC refers to the deviation clause. The said clause being relevant is reproduced hereunder, page 39. A perusal of the above quoted clause showed that liberty was given to the tenderers to quote deviation from the tender conditions. However, in order to do so, the tenderer must attach deviation sheet along with his offer. Another clause which have relevance for the purpose of the present dispute is clause 25 of the SCC, which is the price variation clause. In terms with the said price variation clause, it is stipulated that any offer with a different PVC formula or quoting different base month or linkage with different indices or fixed rate, etc., as compared to the PVC formula provided in the tender would be summarily rejected. What is ERC?
ERC is, my lord, elastic rail clips.
The said clause 25 being relevant is reproduced hereunder, page 34. It is, however, very apposite to mention that the perusal of the SCC also showed that different price variation formulas have been stipulated in reference to different types of works, public supply. As the contract in question pertains to manufacture and supply of elastic rail clips, the price variation formula mentioned therein is at clause 25.5. Which being relevant is reproduced herein under page 38. The petitioner, being interested in supplying the bid in the contract in question, submitted its bid, its bid on 27/12/2021, along with a statement of deviation the deviations which were sought for were as under page 107 of the table খন আছে table খন ধৰে। Next. The materials on record further show that at the time of submission of the bid, the petitioner had quoted 4.5% as the GST. But later on, by the communication dated 30/12/2021, the petitioner submitted that the prevailing rate was 18% of GST. And further submitted that the offer made by the petitioner should be taken as the price quoted along with 18% GST and not 4.5%. On 1/4/2022, a letter of acceptance was issued to the petitioner. Wherein there is no mention as regards the acceptance of the price variation of the deviations as sought for by the petitioner. However, it was duly mentioned that in terms with clause 14.1 bracket A bracket Roman 3 of the tender document, if the tenderer misclassify the goods under relevant GST rules, railway will not pay increased GST due to misclassification. The interesting part. Now, interesting. A further perusal of the letter of acceptance would show that there appears to be mention of a price variation formula. A further perusal of the letter of acceptance would show that the price variation formula, which was otherwise mandated in clause 25.5 of the SCC, was changed. Whereby the factors on the basis of which the price variation formula was worked out was changed. In other words, in other words, a detailed reading of the price variation formula as stipulated in clause 25.5 of the SCC with that of the price variation formula mentioned in the letter of acceptance would show that the manner in which the factors A1, B1, C1, F1, L1 were to be computed were changed. The petitioner immediately upon receiving the letter of acceptance by the communication dated 4/4/2022 informed the respondent number 2 that the letter of acceptance dated 1/4/2022 cannot be said to be a letter of acceptance, but it is rather a counter offer. And hence it was rejected. Be it as it may, in spite of, the records further reveal that in spite of the communication dated 4/4/2022, the respondents issued the purchase order on 27/4/2022, directing the petitioner to supply $480,000 of the elastic rail clips marked of the materials for which the tender was floated, of the elastic rail clips. It further appears from a perusal of the purchase order that the price variation formula was mentioned therein was in terms with the letter of acceptance and not in terms with the clause 25.5 of the SSC. The record further reveals that the petitioner, upon receipt of the said purchase order, issued a communication dated 12/5/2022 giving detailed reasons that there was no formation of a contract and it was illegal and arbitrary on the part of the respondent authorities to impose certain conditions which were unilateral without the acceptance of by the petitioner. A reply thereagainst was submitted by the respondent authorities on, what is the date?
15/6/22,
Page
124.
on 15/6/2022. Wherein there was no mention that the deviation clauses, deviation sought for by the petitioner were accepted. But rather insisted on clause 1.1 of the instruction to the e-bidders, and further mentioning that the petitioner, if did not make the supply, the contract would be terminated by imposing a penalty of 10%.
My lord, here 1.1 also, if your lordship sees this letter, which your lord,
Aha, I know what is there. You don't need to see.
that last part they have not. Very subtly, they have omitted the last part.
The petitioner again submitted a representation on 22/6/2022. But the request so made in the said representation was not heeded too. On the other hand, by the impugned communication dated 18/7/2022, the contract with the petitioner was terminated and the petitioner was imposed a penalty of 10% of the value of the stores not supplied of the value of the stores not supplied. It is under such circumstances the petitioner is before this court. The record reveals that this court, by an order dated 10/8/2022, issued notice and further state the operation of the impugned letter dated 18/7/2022 until further orders. The record further reveals that an affidavit in opposition has been filed by the respondents. Wherein, for the first time, it was mentioned that the petitioner's deviation was duly taken into account, and petitioner being the L1 bidder, the contract was awarded to the petitioner. There is nothing mentioned as regard the change in the price variation formula in clause 25.5 of the SCC. In the letter of acceptance, it was further mentioned in the affidavit that the respondent authorities issued the, what is AAL? Huh?
So it is LOA ought to be, LOA, letter of
Have
acceptance.
issued the letter of acceptance on 1/4/2022. Before it expired on 1/26/4/2022. And in the letter of acceptance, it was clearly mentioned that the contract was concluded and formal purchase order would follow. It was further mentioned that the petitioner having quoted the offer and the order having been placed to the petitioner, it automatically entered into a binding contract and the petitioner firm had to supply the materials within the date of
Date of completion,
date of DP means
date of completion,
date of
D-
P means
DP.
oh Mr. Medhi, what has happened
Delivery period, delivery period.
within the delivery period? What is this type of affidavit file? Huh? And what is AAL?
That is wrongly mentioned, letter of acceptance.
This is LOA.
Who is the council who has done it? Oh, you.
Yes.
Huh? And you are now blaming.
No.
I've heard the learned counsels appearing on behalf of the petitioners and have perused the materials on record. From the materials on record, it is apparent that the respondent authorities, by issuing the notice inviting tender, had invited bids from all bidders, from all interested bidders for the manufacture and supply of elastic rail clips. The materials on record further show that in terms with, as per the terms and condition of the invitation of, in terms and conditions of the invitation given by the respondent authorities, which included liberty being given to the bidders to submit bids with deviation. The petitioner submitted the bid with the deviations, as already mentioned herein above, as already mentioned in the previous segments of the instant judgment. The record further reveals that on 1/4/2022, the respondent number 3 had issued the letter of acceptance, wherein there is no mention as regards the deviations which were sought for by the petitioner. And further, changing the price variation formula as was mandated in clause 25.5 of the SCC. The question therefore arises, can the issuance of this letter of acceptance be said to be a concluded contract? For the purpose of the same, this court finds it pertinent to take note of some of the provisions of the Indian Contract Act 1872, for short the Act of 1872. Section 2 of the Act of 1872 is the interpretation clause and gives in a vivid manner as to how a formation of a contract takes place. Section 2 of the Act of 1872 being relevant is reproduced hereinunder. From the perusal of the above quoted provisions, it will be seen the provisions above quoted, if applied to the facts of the instant case, would show that in pursuance to the invitation of the bids, the petitioner as a promisor submitted its bid containing certain terms and conditions. Let me come back, huh? Yes, affidavit file.
Yes.
Yes, for Itanagar matter.
The Lordship, till now, Lordship, respondent number 11 only filed their counter affidavit, Lordship.
Matter pertains to what?
My lord, I am appearing on behalf of respondent number 11. I filed my affidavit in opposition. The matter pertains to promotion of UDC to Sreshtidhar, my lord. We were recruited through a common recruitment process. Thereafter posted against different districts. Now it is the claim of the petitioners that there has to be a common seniority list of those UDCs who were appointed through a centralized recruitment process.
Who appears for the High Court?
My lord, I'm appearing on behalf of Senior Advocate Muk Purton, sir. I'm appearing on behalf of Senior Advocate Muk Purton. He's currently out of station, attending a funeral of a close relative.
Mr. Mohanto,
Mukpur.
you are the senior, you are also the standing counsel of the High Court. In this case, what has happened? A second file to Asane. Right. Yes. Here, why is only Mr. Patin appearing when the Registrar General is also a party in this proceedings? Registrar General Guwahati High Court is also a party.
Probably, my lord, the filing Itanagar is not communicated with level. Ultimately, if it is communicated with here.
No, and the problem which is this court is facing is that the Registrar Guwahati High Court Itanagar bench is not taking any steps. No affidavit has been filed by the respondent numbers 1 to 10. And various opportunities have been granted. Only the respondent, private respondent has only filed the affidavit. So we will say that the Guwahati High Court doesn't want to file an affidavit, we take it up without the affidavit.
My lord, so far, my lord, I don't know the number, I don't like it with my lord. There is probably whether there is any information here or not, that has to be, my lord.
Because
My lord, suppose, my lord, suppose,
because the
there is a
selection,
I told in the Itanagar, they have received the copy, then not informed to the registry, my lord, of the Guwahati High Court, the principal seat. Then, my lord, without notice, my lord. Whether
selection
there
was,
is any communication from the
Standing Council, Guwahati High Court, Itanagar Branch to the Standing Council, that raised to be Guwahati High Court.
This advertisement was issued by, who has issued the advertisement?
What has-
Yes, counsel for the petitioner.
Page number 1,
Where is the advertisement?
page number 50.
Ito na. This, Lordship, advertisement was issued by Registrar Administration come in charge recruitment cell, Guwahati High Court.
Page number.
It is at page number 50, Lordship.
Page number?
50, 50.
You don't know. This is an old advertisement. There is another advertisement. Which advertisement are you for filing the petition? Where is the advertisement of 18/7/2021?
Wait. Do you want this?
I have to cancel. This was cancelled.
Yes, counsel for the petitioner. Argue. Let us take up the matter. If you have a case, we'll allow the petition. If you don't have a case, we dismiss your petition. Argue.
Lordship, I'm appearing on behalf of Mr. Deepangin, Lordship. He is out of station, Lordship. So kindly, I may be given some
Not
time.
aware
Lordship.
that the matter is listed today.
No, Lordship, I was just informed, Lordship.
If you are not interested, then we adjourn this matter sine die to be listed only after 10 years. When are you retiring?
Pardon, Lordship.
When are you retiring? 32, 30, and 33. You have not got the job, is that? You don't know anything. The counsel for the petitioner is not aware of the facts when this court inquired. It is further unfortunate to take note of that even after various opportunities being granted, the official respondents have not filed the affidavit. Full stop. Considering the above, we dismiss the writ petition.
Lordship, kindly, I may be given, Lordship,
No.
sometime, Lordship.
Yes, counsel for the respondent number 11, can you say anything about the case?
Yes, my lord. My lord, initially, petitioners and some of the UDCs were recruited through a centralized recruitment process initiated by the High Court.
Come to the mic properly.
My
Argue.
lord, initially, the petitioners and some other UDCs, upper divisional clerks, were appointed through a common recruitment process. Thereafter, we were allocated different districts or courts. The petitioner number 1 and 2, they were allocated district and session judge, the court of district and session judge UPA. At the relevant point of time, there were few sessions division. Subsequently, new sessions divisions were created. And initially, the respondent number 11, she was allocated the court of additional district and session judge Bombila. Subsequently, that additional and district and session judge was upgraded to Sessions Division, my lord. Now, it is the claim of the petitioners that since we were recruited through a common recruitment process, therefore, there has to be a common seniority list of these persons who were recruited through a common seniority list. Because I being by virtue of posted in Bomdila Sessions Division, I was the senior most UDC in the district-wise seniority list of that district. Therefore, I was promoted to the next post of Seshtidar. The petitioners who were posted
Okay.
against UPA.
I am satisfied, Mr. Counsel. We dismiss the petition then.
Yeah.
Yes, what is your name? Counsel
B.
for the
Lonalos.
petitioner, we dismiss it.
Lordship,
All-
kindly I may be given
10,000
one
cost.
opportunity, Lordship.
10,000 is less. 1 lakh. 4 petitioners. 4 petitioners, 25,000 each. You want an adjournment? Adjournment. These matters doesn't come like this, no? The respondents, numbers 1 to 10, were given various opportunities for filing the affidavit. But no affidavit has been filed till date. Full stop. Considering the above, this court shall proceed with the disposal of the instant writ petition. By taking into account that the respondents numbers 1 to 10 have duly admitted the stand of the petitioner. List this matter for disposal on 6th of November 2025. Taking into account, therefore, as the pleadings are complete, as the pleadings have as the respondent number 5 has 11 has already filed the pleadings on 18/9/2025, and the petitioners having not filed any reply thereto, this court would take up the instant writ petition for disposal on 6/11/2025 at 2 p.m. to the video conferencing link.
Obliged.
Yes. Did you file an affidavit?
Lordship, I filed on 18th September.
In compliance to the following.
Lordship,
Whether there is any provision prior to the Iman which restricted granting of invalid pension to those persons who have not completed study is being taken up. May take into account the website and take special. So invalid pension would be there, Mr. MT.
Lordship, as per the CCS Rule 1972, is invalid. But in the present case, the petitioner is praying for disability pension. So, Your Lordship, I have a humble prayer that since we have a matter on 20th of this month regarding the infrastructure development matter, so I need to seek some collaboration from the department, and if the matter is listed on 20th of this month, because other matter also is listed, Koima Bench matter. So that is my humble prayer before Your Lordship. Dear CCS Rule 72 says invalid, whereas a petitioner prayer is a disability pension. So there is a little variation of this. Otherwise, the CCS Rule 1972 is applicable in the state of Nagaland, as per the ROBCL dated 18 June 1987. That is Annexure A to my affidavit.
So in the state of Nagaland, the CCS pension rules were made applicable from 1972.
Lordship, since 1987, my annexure
But
affidavit.
anyways, in 1987,
Yes,
it was applicable.
yes, that.
As could be seen from the affidavit,
Yes,
additional affidavit that the CCS pension rules was applicable.
yes, Lordship.
So therefore, the question is, one, that you don't have any materials to show that he was already inflicted with that particular
Yes,
disease prior to entering into service.
no,
Secondly, you discharged it holding that he was not in a position to carry on the job.
Yes, yes.
So therefore, as per your affidavit and taking into account the judgment of the Supreme Court in that Dharmeshwar what?
Dharamveer Singh.
Dharamveer Singh,
Yes, Lord.
the petitioner would be entitled to invalid pension.
Lordship, if you go by the CCF Rule 1972, Rule 49, Clause 2, then the petitioner is not qualified. That as per the Rule 49, Clause 2 says the applicant has to complete 10 years in service, but here the present petitioner is not. So that is our stand only, Your Lordship.
Lordship, in that regard, the notification was issued only in 2015. So I was ported out from service in 1991, Lordship, prior to 2015 when the said memorandum was issued.
No, I am not relying on the memorandum, but I rely on the Annexure 1.
That was the reason
Annexure 1.
why my application was rejected, Lordship, in the reply to my legal notice.
Mr. Imsong, did you look into this recent judgment of the Supreme Court? Although it is a case of pension, in a case of a pension where the court did not permit after a very long period,
Lordship.
taking into account this is a case where the petitioner was released in the year 1991,
Yes,
then he submitted his representation in 2009 and approached this court in 2024.
yes. Lordship, that objection I have incorporated in para number 6 of my affidavit in opposition also.
Huh?
There is my affidavit in opposition, para number 6, because there is a inordinate delay in claiming the right of the petitioner.
Because you have lost your chance also. There is a recent judgment. I think it has come up around 10-15 days back.
Lordship,
Have a look at it.
Lordship.
We will again take up the matter next Thursday.
Lordship, I may also be allowed to submit on that
Huh?
on that delay question.
What do you want?
Lordship, I may be allowed to reply to that on the delay
You want to
question.
reply to the affidavit in additional
No,
affidavit
Lordship, on the question of delay.
on the question of delay?
Query that your Lordship has risen.
Okay.
When the matter is taken up.
So
next.
next week, is it possible?
Lordship, next week Thursday is so.
Otherwise, Lordship, we have a matter, Kohima bench matter on 20th of this month. If it's club with that on that very day,
21.
20th of this month.
20
month.
for this month is already gone.
No, next month, November 20th. Infrastructure matters. We have already fixed. So if the present matter also club on that very day,
20.
20 November.
Okay. Mr. Counsel for a petitioner
Lordship, I will be here, Lordship.
on 20.
20th of November.
This court have duly taken note of the additional affidavit which have been filed by the state of Nagaland pursuant to the order passed by this court on 4/9/2025. First, the counsel appearing on behalf of the petitioner submits that the petitioner would like to obtain instructions from the petitioner in that regard, and further file additional pleadings if so necessary in that regard. List the matter on 20/11/2025 at 2 p.m. I think I may be there at that point of time. ASCII line লিখলে এটা কোড কইল না In the backdrop of the above provisions quoted, it would be seen and applying to the facts involved in the instant case, it would be seen that the respondent authorities by issuance of the notice inviting tender containing various terms and conditions had invited offers from eligible bidders for the purpose of manufacture and supply of elastic rail clips. The petitioner herein on the basis of the said invitation for offer by the notice inviting tender dated submitted the bid on 27/12/2021. Stipulating certain deviations as have been already mentioned here in above. At this stage, this court finds it very pertinent to take note of Section 7 of the Act of 1872 which is a provision dealing with when a proposal can be converted into a promise the said section being relevant is reproduced herein under. Now, applying the said provision to the facts of the instant case, it would be seen that the petitioner herein had submitted the proposal pursuant to the invitation of the offer. Containing various terms and conditions. The proposal so submitted, as already stated, was subject to certain deviations as sought for. However, while accepting the same, by the issuance of the letter of acceptance on 1/4/2022 by the respondent authorities, the deviations sought for were not accepted, were not seen to be accepted. It is also very pertinent to observe that in the letter of acceptance, the respondents have changed the term pertaining to price variation formula, which was mentioned in clause 25.5 of the invitation or of the notice invite of the special conditions of the contract. The act on the part of the respondents, therefore, to change the term of the invitation of the offer by incorporating it in the letter of acceptance dated 1/4/2022. Can at best be said to be a counter offer being given by the respondents to the petitioner. It is further seen that the petitioner, having noticed that the clauses of deviation, the deviation so sought for having not been accepted in the letter of acceptance dated 1/4/2022, and further the respondents having changed the price variation formula by the communication dated 4/4/2022, refused the letter of acceptance. The refusal of the letter of acceptance, in the opinion of this court, that too within a period of 3 days from the date of issuance of the letter of acceptance, under no circumstances led to a concluded contract. Under such circumstances, the consequential effect thereof, therefore, was that the respondent authorities could not have issued the work order, the purchase order, on 27/4/2022 without there being a concluded contract. And further, and it is also the opinion of this court that even if such purchase order was issued, the said purchase order could not have bound the petitioner, as there was no concluded contract. First. The natural corollary, there's a word used now, what I forgot. How will this? Corollary. Little boy. The natural corollary, therefore, the natural, the concept, the this goes further, is of the opinion that if there was no concluded contract and the purchase order dated 27/4/2025, 22 could not have bound the petitioner. The question of termination of such contract or imposition of penalty on the basis of such contract or termination of such contract or imposition of penalty by the impugned communication dated 18/7/2022 could not have been made by the respondents. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The impugned communication. Now, first, number one, there was no concluded contract by and between the petitioner as well as the respondent. Petitioner as well as the respondents. In respect to the notice inviting tender dated so and so. Number two, the impugned communication dated 18/7/2022 is bad in law and contrary to the settled principle is contrary to the settled is contrary to the settled principles of law, and accordingly stands set aside and quashed. Number three, there shall be no order for costs.
I'm deeply obliged.
Your Lordship may have a look at your latest order by your Lordship, my lord, where certain observations were made by your Lordship.
Yes, Mr. You were supposed to make the submission.
Yes, ma'am.
Yes. No, natural justice, the notice itself was the final order of
Huh?
recovery.
May I take your lordship to annexure A, NIT dated 26/12/2016 at page 133 of my affidavit in opposition.
Page
133. NIT dated 26/12/2016. And at page 135. The items are mentioned which is to be carried out by the contractor. And there was some corrigendum instead of item number 98 at column 3, my lord. Page 135. Corrigendum is at page 127.
Yes,
My lord, at page 137, my lord.
137.
137. Down below is revised and corrected items.
there are 7 items. After the completion of the contract, the contractor was paid the money and the contractor has filed,
This
no
is
demand-
short term tender notice for appointment of monthly labor contract.
My lord.
Please refer to the relevant terms of the handling as defined in the price bid applicable to PPC AI as circulated in the NIT. The following correction may be incorporated in the items so and so as depicted. The item at serial column number 3 may be read as item number 19 of the MD instead of 19A of so and so. Circulated items in NIT dated 26/12/2016. Filling of gunnies, weighment, so and so, so and so, so and so, so and so, so and so. Revised corrected, filling of gunnies, weighment, filling so and so. The other items of the year shall remain unchanged. Now, tell me, Mr. Singh, only aspect is here. Do you fix the rate individually or as a whole?
Lord, as per the MPF, against the, it has been defined, the item number 1 is at page 72, my lord.
Page?
72 of the writ petition.
Ah.
10-1. Page
10-1.
10-1. For filling gunnies up to a prescribed weight, the gunnies as mentioned in clause 19, part 1, 10. Number 1 is taking in the same go down. So staking would take place of, they have to fill up the gunnies up to 40 kgs, meaning thereby they will make a weighment of 40 kgs weight and they will now stack it. Now, as per the CAG report, this item number 1 and 2 is the same component, my lord. It has to be clubbed under single operation because only one operation has been taken place. Item number 8 and 10-1.
No, that is okay. This is the notice inviting tender.
Yes, ma'am.
Schedule of rates and services for handling of transport contractor of FSD. Okay. Now let us see this is the rates. Who has quoted these rates? This is the price bid.
No, this is the rate fixed by the Indian
Yeah,
MPO and they have quoted 320% above the schedule rate.
You have quoted, what is the rate quoted by them?
Rate quoted by subject.
Now kindly see the rate of
320.
transport of grains quoted in the preceding items number 267 is subject to the following terms. The rate for transport of food grains is on the basis of net weight of food grains per year. No separate remuneration will be payable for part of the gunnies as the remuneration thereof shall be deemed to be included in the rate for transport of net gains foodstuff. Transport charges shall be payable for 1 kilometer and when the distance covered by the loaded so and so. The distance. The transport charges are payable for the distance covered by the loaded truck so and not for distance covered on return journey. No compensation shall be admissible so and so. Okay. Now, where is the rate? He was given at what rate? Show me that.
Yes. The appointment letter is at page 25, madam. May I read it, madam? Page 25. You are hereby appointed as handling contractor at page 25, madam, annexure 1. Twenty-five of the rate section. You are hereby appointed as handling contractor at Nauka on ad hoc basis for a period of 2 months with immediate effect at the quoted rate of 319% above schedule of rate. So in the MGF rate is given and above this 319%, he was appointed.
So, how did you make the payment? Means?
Like in item number 10, staking of one bag is rupees 168. So 168 plus 319% above schedule order. This is the schedule of rate.
Okay. So he had quoted
390.
You have against each item or AR at the quoted rate of so and so. Means how did you arrive at 319% AR, sir?
They have quoted 319% above schedule of
In each of the, in each of the,
in each of them. No, not the MTF.
No,
whatever
did
item
they-
has been mentioned in the MTF, not necessarily they have carried out those items. Those work.
no, I'm not on that. Is it against each of the items?
Against each of the item, my lord. Because the
So
items
how
are
did
mentioned in the
how did
annex.
you arrive at 309%? You are saying that 309% is the question. How did you arrive at 309%? Means it's an average. Is it an average?
Yes, as a whole, 319% of the work which has been mentioned in the NIT.
So therefore, how do you make the payment?
Payment, this schedule of rate is mentioned in the MTF.
No, kindly come to,
page 72,
no,
my lord.
kindly come to at page 76.
Here it is, my lord, he is a handling contractor, not the transport contractor, my
Huh?
lord. He is handling contractor.
This is for handling contractor. Then why you are showing me this document then? This is a part of the handling contractor.
I'm showing the page 72, my lord.
No. You see, this is a note to that. The note to the price bid,
My lord, kindly come to page.
which is the tender for handling contract and transport contract. Now, what is the contract he has entered into?
For handling contract.
Handling. So this is a model form for handling and transport contract.
I think he has annexed the wrong EA.
Huh?
My lord.
What?
It ought to have been a handling contract, my lord. Because handling contract and handling and transport contract, MTF are almost same, my lord.
No, it is very difficult to understand. Means how, at what rate you are giving means as to how, what is the rate? Quoted rate of above, of 300% above AR per bag.
Per day,
So per bag you are giving a particular rate.
Yes,
You have fixed one rate.
1 day.
How did you fix one rate?
My lord, kindly come to page 72, my lord.
Page 72.
Item number 10-1.
So he was only given only 10-1.
No, we have given 7 items,
Hmm.
which are defined in item number 10-1, item number 8.
No, but this is not mentioned in your order.
It is mentioned here, my lord.
No.
NIT.
No, this is not the NIT. I'm saying, how are you doing it? Because if there are 10 contract items to be carried out,
10, man.
or seven
Seven.
items to be carried out, means are you giving against all the 7 items
We-
319%? Because that is not mentioned.
It is mentioned in the NIT, my lord. At page 135. Lordship will come to page 137, the after corrigendum, my lord.
Yes.
Item number 1 is filling gunnies with prescribed weight and staking. Item number 10-1. That's why I'm showing page 72, my lord. 10-1 is defined.
Hmm.
What work is to be carried out and what is the rate. Again, item number
Wait. The handling of food grains at these mandis will be the relevant items of operation as defined in the following items of the price circulated by the circle. The relevant items of handling as defined in the price bid applicable so and so are these. Separate remuneration will be admissible for loading and unloading of gunnies as so and so. The other terms and conditions will be governed by the HTF technical bid for relevant year. So therefore, my question is, how did you give the rates? If there are 7, did you separately make the rates?
Against each item, there is the rate, my lord, defined in the MTF.
But it is not mentioned there. Means therefore, I'm saying in each case, against each of the 7, which is there in the price bid, you have given above 319%.
Yes, my lord.
Where is your statement to that effect?
The appointment letter is there.
The appointment letter doesn't say so. No, against each of the items. It says you are being given for handling contract above 319% above the quoted rate.
Yes, my lord.
Quoted, was there a quotation made by him for all separately?
No, my lord, as a whole, he has given.
So they must have given one figure.
One figure that is
They must
319.
have given 1,000 rupees, 2,000 rupees, whatever it may be. They must have given your rate was some 500 or 600. they must have got 500 or 600, they must have given into 300 times would be around 1500, 100.
I guess 100
100.
rupees, 300.
Around
300.
rupees they must have given, for example. So they have given one rate.
Each item has been defined in the MTF, the rate is defined. my lord.
Understood.
So
But
I-
they have they quoted individually.
No, they have not quoted individually.
So they have given a cumulative amount
Yes, 319% above the schedule.
above the rate. So they have quoted in that manner.
Yes, ma'am.
Let's see how they can quote as per the terms and conditions.
At page 134, ma'am.
That's tenderers should submit both the tenders technical and price bid in separate manner. All credential, the copy of the income tax, so and so, so and so, so and so. Technical bid shall be accompanied by earnest money. So and so, so and so. The subscribers shall deposit 5% of the decision. Price bid, where is the mention? Will have to execute an agreement in terms with the so and should quote competitive rates to avoid negotiation, as no negotiation will be conducted with any of the bidders who participate in that. It should be clearly understood by the tender that no opportunity shall be given to them to alter, modify, or withdraw any offer at any stage after submission of the offer. The quotation, that is price bid, should be on letterhead of the firm dealing with the Mandi work and must be accompanied by Annexure A, duly signed by the proprietor of the firm and or his authorized representative with name. What is Annexure A?
Annexure A is the MTF, ma'am.
Huh?
Is the model tender form.
Then the handling of food items in the air will be relevant items of operation as defined in so and circulated. And the relevant items of handling as defined in so and so. Separate menu will be admissible for loading and unloading of gunning. We are not going. Other terms will be governed by the money. The copies of the price bid and the technical may be obtained by the FCI. The rate is to be quoted on ASR basis. What is ASOR?
Above scheduled of rate.
Rate basis. So they have quoted, there might be 7 items, but they have quoted one rate.
One rate.
So you have given him at that rate. Later on, 4 years down the line, now you have realized,
After the-
we
after
gave
the
them
audit-
all these things. Now we find that 4 or 5 works were actually not given to them.
Till they have not conducted that work, my lord.
Not conducted means did they, you see, if this is the notice inviting tender and this is a part of it, page 135, they have quoted ASOR cumulatively for all these 7 together means one rate.
One rate.
So whether you get that work done by yourself or not, or they did not do, can you just wake up after 4 years because they have done it? You should have given them less amount. You shouldn't have given them the tender.
We have paid it, they have submitted the no demand certificate. The no demand certificate was being processed by the MCI. Meanwhile, the audit report has come, my lord, and it has. been
And that's
printed
true.
out.
Now the audit must have got hold of, look here, these people, these are the works which they were not required to do. You see, these
For
are,
example, my lord.
it is
one
more
and
like-
two is the same component, my lord. They are not weighing 2 times. 1 and 2 is the same component, my lord. Like packing the bag and weighing the
no,
bag.
but Mr. Singh, the question is, did you pay them as per the rate they quoted?
Yes, my lord.
So once you
Under
paid them as per the rate they quoted, now they quoted one rate for all components. They did not quote separately.
No.
If they had quoted separately, the question would have been, okay, this particular work was never done or allocated to them, and as such don't pay. But once they quoted the entire thing cumulatively,
But we have paid them separately, my lord, for each work.
you paid them, it is a different thing, but they quoted for the work. Whether these 7 components were not a part of that handling contract. Yes. My question is whether the 7, which is there in page 135, not a part of the handling contract. Yes. You
It's a
give
part
them
of
a
the-
handling contract.
It is a part of the handling contract.
Understood.
That Wayman is
And
done
for
only
that they
once,
quote,
my lord.
and for that they have quoted cumulatively above 319% above AOC.
Yes, so against each.
Not against each. They have quoted. So show me that they have quoted individually against each.
Not individually, but for the 7 works. my
So for the 7 works you have given them, okay, you particular these are the 7 works you have to do, and this is the rate at which we are going to pay.
lord. Yes,
They may not have done 3 or 4 works.
yes.
They have only done 1 work.
1 work.
But to your satisfaction that was enough. Just for example, tomorrow you ask somebody, they go and get a particular thing from the market, and I will give you this amount. Now he, instead of, you take into consideration that he will go, so I have to pay him some auto rickshaw fare and also some amount. Now he gets hold of, he meets Mr. Barbara on the way and he says that, okay, I'm very kind enough, I'll give you a ride to that place. And he goes free there. Or Mr. Barbara is here, he reaches here, he has the goods. So he says, okay, let me give it.
My
Now,
lord,
can you later on say,
example-
that, look, yeah, this particular person, he didn't go.
My lord, this example will not fit in, my lord.
Why?
My lord, the payment is done only once, and staking is done only once, staking of the bags. When it will be loaded, my lord, then it is de-staking, my lord. They will de-stake it and they will put it in the truck, my lord.
But the
So
question-
that payment is only once, my lord. That was.
Then why did you make the payment?
Yes, we have done it. We have inadvertently, we have paid it later on. It was reflected in the CAG report.
The CAG report has reflected it, but you have to satisfy me only on this thing.
My lord, one chart is there, Annexure D, my lord.
Annexure?
Page 158.
Page
58.
Let us see.
These are the work done by him, and against each item of work it has been paid.
Okay, let us see.
150.
Yes.
Particulars up to, this is staking of up to 10 feet height up to 11, 16. Then breaking stakes. Breaking stakes which we had paid, now we are realizing it. And then weighman. Because staking the bag will be after weighman only. The item shows that you have to stake it up to 10 feet after weighing. So weighman was not done separately. So we have deducted this amount, weighman and breaking stats. It has been given monthly wise, January 17, February 17. So it comes to 18 lakhs. We have recovered 8 lakhs and 10 lakhs we wanted to recover. Now my learned senior.
No. These must have happened later on.
Yes, it has been later on.
It was later on. But my question therefore is, whether did he quote for these 7 items together?
7 items he has quoted together.
Then how do you say differentiate it? And he has done the work to your satisfaction.
Suppose he had quoted the work separately. Even then we.
Then the question is, you did not give him that work. He did not do it.
Even then we would have deducted that work.
How?
Deducted that item, my lord.
How? Show me that provision by which you could deduct that there can be bifurcation of these 7 works.
Yes, it has been there in the MTF only, my lord.
Show me. Where is the
Page
bifurcation of
Page
this?
72, my lord, for example.
No, this is a pride bid.
This is the price bid, this is the price bid, and this is the.
Singh, no.
To be conducted by the.
No, Mr. Singh, once he quoted for the entire quote, for the 7 items together, show me that it can be bifurcated as per the terms of the tender. Not this price bid, this is quotation. Just for example, tomorrow, Mr. Singh, kindly listen. Tomorrow, you are given a turnkey project. For that, you have to give a SOP, SOA, statement of articles or statement of rates for each SOR, that this will be this much, this will be this much, and therefore this is my project. Isn't it? And this is how he must have quoted this also. And pursuant thereto, you see that some of the things were not required.
Yes.
But it is a turnkey project. You have agreed to this particular rate for all the 7 items. You have to give patents.
Okay, my lord, that was a turnkey. Here it is not a turnkey, my lord. We have
No, therefore you show me, no, if it is a handling component had 7 items, components, handling contract,
Yes, ma'am.
that you can bifurcate it. Show me that in the terms of the tender, not the price bid.
This price bid.
No, price bid is means
What
no,
what has to be
no,
given? My lord, can you
no,
see
no,
item
no,
number
no, no,
8
no,
and
no.
10, same work, my lord.
No. These are things, you just show me whether there can be, is possible to bifurcate that rates. Show me.
The rate of the petitioner, my lord.
Huh?
Rate of the petitioner.
No, rate of the petitioner can be bifurcated.
No, he has given as a whole 390.
So therefore, how do you do it? And you were satisfied he did the work.
No,
And after 4 years, you woke up. Isn't that Mr. Borbara?
Yes,
no, my matter was
In
not
4 years,
ended, the contract was not
4 years,
ended.
at no-
NDC was on the process, my lord. We have
At
not
no point
accepted
of
the
time they
NDC,
objected.
only one certificate.
4
So
years,
it was
suddenly
still
they
open
give it.
here.
No point of time they objected. They have a mechanism of audit and accounting for disbursing bill scrutiny. They did it after 4 years. Absolutely.
No. The question is, can you bifurcate?
We can bifurcate from the, my lord.
No. No, show
The
me from the
technical-
terms and conditions entered into, mister. Kindly show me from the terms and conditions, not from the how he has quoted, how he has reached the amount. I am asking you, can you bifurcate the work?
This NTF is itself the terms and conditions, man.
Understood. This is how you quote. I'm not on that, but can you bifurcate? You are giving him a handling contract. Handling contract has 7 components. Can you bifurcate? If you can, very well, show me one line, enough. I am satisfied. I am otherwise satisfied with your case, but I am not satisfied with the explanation given. I understand that he didn't do the work for which you want the money.
Yes.
No doubt, everything is true. But the fact remains that can you bifurcate?
Composite and integrated work.
It's an integrated work. That is the question.
My lord, subject to correction, it is not integrated work. Each item is.
So
defined,
therefore, there will, if it is not an integrated work, there will be a provision for bifurcation.
That what I am showing from the description of service he has to render.
No. Are you, that is a SOR. That is an SOR. Take it as an SOR. I am asking you, how can you bifurcate must be there in the terms, na? Because you see the handling contract has 7 components. Out of, can you component, okay, 3, 4 can be taken out. If you can bifurcate that, very well. Or you can say that if some terms have not been done, which is the scope of the work, then the money would not be paid. Show me one term to that effect.
We are saying that at least item number 3, 5, and 6 was never undertaken.
Understood, but it has to be as per the contract, na?
That is what I want to satisfy your lawsuit from the description of the work.
No.
Item Number 3 is.
Then how do you bifurcate? You cannot bifurcate in this manner. Or as a whole, it may be another case that there were 10,000 quintals of 10,000 bags. They have done 5,000. Okay, that is permissible. But otherwise, how do you bifurcate? No case. Good case for the petitioner. I gave you an opportunity, but you failed.
I have to satisfy your lordship from the all papers available, my lord. So the CAG report says that item number 3, 5, that we also.
No,
Taking stake and
no,
stake and
Mr.
restaking
Singh,
was never undertaken.
CAG comes up with many reports. And we know the fate of the 2G scam also.
Yes, ma'am.
So we are not on the 2. CAG cannot be taken to this. So, but my question therefore here is, can you bifurcate. If you can't bifurcate, matter ends. Small question. So can I dictate? Let me dictate then. Art, Mr.
On this pilot, about national, same party, there are some 2 or 3 single judges that those are not binding on your lordship. So that you cannot unilaterally issue.
What?
Forget about unilaterally recover without notice.
Why should we go? I say,
Not necessary.
we go into the fundamentals.
Yes, sir.
That is more on natural justice.
Yeah. Natural justice.
Let's go on the fundamentals
Yes.
that it could not be bifurcated. If it could not have been bifurcated, they could not have segregated. So it is one component, one work.
And 4 years after,
Unless you have Article 366(29)(a) to your benefit.
Logic.
So let me come in 5 minutes.
Of this break to ask them the bifurcation of work. They are also repeating same thing. The description of services is that is only the.
Understood. So it has to be there in the schedule of rates and not schedule of rates. While granting him the contract, you have to say to that effect.
Against each item, there is a schedule of rate, and he has quoted above schedule of rate as a whole.
Understood. So that is how you have to say so.
And
That if you don't do this particular thing, this is an SOR. Schedule of rates, he has given his schedule of rates. And against that, you have come to a finding that, okay, we give him this particular, for the purpose of handling the contract, we give him at so and so. At 319% above the ASOR.
Another thing is that when they have submitted their NDC, that is no demand certificate on 15/5/2018. It was still under process and meanwhile this came. So the contract has not ended, so that's why it is still open. My understanding.
Hey, that is okay. It's not concern. I'm not on that. That is why I'm not going into those technical. Heard Mr. A.C. Barbara, the learned senior counsel, assisted by so-and-so, appearing on behalf of the petitioner. Mr. B.K. Singh, the learned counsel, who appears on behalf of the respondents. The petitioner herein have assailed the communication bearing number 15/9/2021, as well as the order dated 9/8/2022, and further sought for direction upon the respondents to pay the security deposit amounting to rupees 8,73,116. The facts, the necessary facts relevant for the purpose of disposal of the instant writ petition are as infra. A notice inviting tender dated 26/12/2016 was issued by the respondent authorities for handling contract at Nagaon. The said notice inviting tender have been enclosed to the writ petition the said, it's not a notice, it's a, you have enclosed the model form, no?
Model tender.
Was issued on 26/12/2001. You have a copy of that?
I have annexed it, my lord.
Notice inviting tender.
We have an.
They have annexed
Page
133, page 133.
It's an appointment of Mandi labor.
Issue the short-term tender notice for appointment of Mandi labor contract. Dated 26/12/2016.
It was initially for 2 months, then extended for the entire Kharif marketing season, ended in 2017.
for the purpose of executing Mandi labor operations for No. The respondent authorities have issued a short-term tender notice for appointment of Mandi labor contract in a two-bid system, from thereby inviting from interested financially sound parties having business competency. The scope of the said work is to execute Mandi labor operation for appointment of Mandi labor contractor at a designated paddy procurement center for stenciling, peeling, dumping, stitching, unloading from scale, loading in trucks oblique carts within FCI district Nagaon, comprising revenue district Hojai, Nagaon, Morigaon and Karbi Anglong for Kharif marketing season. Bracket KMS, bracket close 2016-17, brackets Sali Pedi, bracket close, commencing 1/1/2017 for an initial period of 2 months with provision to extend or terminate the contract at the discretion of the FCI or till any other alternative arrangement by the FCI. In terms with the said notice inviting tender, various terms and conditions have been mentioned as to how the technical bid as well as the financial bid was required to be submitted. For the purpose of the instant case, clause number 7 of the said notice inviting tender being relevant, clause number 7 of the said notice inviting tender is relevant in as much as the said clause stipulates that the handling items of food grains at the mandis will be the relevant items of operations as defined in the following terms of the price bid of HTC circulated by the regional office Guwahati. It is further seen from the said clause that the relevant items of handling in the price bid had 7 components. That is, number 1, filling gunnies with prescribed weight and stacking. Number 2, weighment. Number 3, for breaking stack. Number 4, loading in trucks. Number 5, breaking of stacks and restacking. Number 6, supply of casual labor. Number 7, loading oblique unload gunny. It is further stipulated in the said notice inviting tender that the rate is to be quoted on ASOR basis. ASOR basis means
Schedule of rates.
above schedule
Of rates.
of rates. Bracket close basis. It is further pertinent to take note of that in the said notice inviting tender, there is a reference to the model tender form. A perusal of the said model tender form stipulates the schedule of rates and services for handling and transport contractors at FSD. The petitioner participated in the said notice inviting in the said tender process. And by the communication dated 4/1/2017, the petitioner was appointed as the handling contractor at PPC Nagaon. For a period of 2 months with immediate effect at the quoted rate of 319% ASOR per bag on terms and conditions as contained in the tender agreement. A perusal of the said appointment order dated 4/1/2017, however, do not mention that there is a bifurcation. Do not stipulate any rates individually in respect to the 7 components which form the handling contract. Rather, the entire handling contract cumulatively was the contract awarded to the petitioner. The record further reveals that the said contract was extended from time to time at the accepted rate of 319% ASR. And the said rate and the said extension till what time?
October 2017.
Till October 2017.
Paragraph 5 of my report.
The petitioner demanded for the petitioner upon completion of the contract sought for return of the security deposit as well as the no demand certificate. The respondent authorities did not issue the no demand certificate, the respondent authorities neither issued the no demand certificate nor returned the security deposit. However, after almost a period of 4 years, a notice was issued to the petitioner on 15/9/2021, wherein it was mentioned that on the basis of certain observations made by the, what is SCAG?
Comptroller and Auditor General.
Comptroller and Auditor General, there was excess payment made to the petitioner. And as such, the security deposit was adjusted against the said excess dues. of the petitioner, which was found to be to the tune of rupees 1877,217, and the petitioner was therefore directed to pay an amount of rupees 10,04,101. The petitioner thereupon submitted a representation, however, to no avail. Resultantly, the petitioner had to approach this court by filing a writ petition, which was registered and numbered as WPC number 1119/2022. This court, by an order dated 21/2/2022, disposed of the said writ petition. At the motion stage, directing, thereby granting the liberty to the petitioner to approach the concerned dispute/grievance redressal committee for redressal of its grievances and disputes, etc., by submitting its representation stating its grievances and/or disputes before the General Manager Regional, Food Corporation of India, Regional Office, Assam Region, Paltan Bazar, Guwahati. It may not be out of place to take note of that from a perusal of the impugned order of the order dated 21/2/2022, the learned coordinate bench of this court have duly taken note of the grievance of the petitioner that such notice which was issued on
Page 53. 15/9/21.
15/9/2021 was without following the mandate of the principles of natural justice. Be that as it may, in view of the liberty so granted by to the petitioner by the order dated 21/2/2022 in WPC number 1119/2022, the petitioner approached the
Dispute Redressal Committee.
grievance dispute, the grievance redressal committee by submitting a representation on 25/4/2022. The respondent number 2,
Gentlemen.
the respondent number 2, by the order dated
Page 65. 9/8/22.
page
Page 65.
85.
65. Ending at page 68.
By order dated 1/8/2022.
This is 9/8, Lordship.
9/8, na?
9/8.
9/8/2022. 9 or 7/8? 9/8/2022. Rejected the said representation appeals, the representation submitted. And it is under such circumstances the petitioner has approached this court by filing the present petition. The record reveals that this court, by an order dated 26/8/2022, while issuing notice, state the operation of the impugned order dated 9/8/2022. The interim order thereupon have been continued from time to time. The record reveals that the respondent number The respondents have filed an affidavit in opposition. Wherein the stand so taken is that in the report submitted by the CAG during the transaction audit for the period April 2014 to March 2018, it was found that excess payment was made to the MLC bracket Monday labor contractor during KMS 2016-17, for which NIT Trader was appointed as MLC for PPC Nagaon. The CAG further observed that the items specified in serial number 1 and 2 of the price bid have to be clubbed under single operation, inverted comma, filling up gunnies with loose grains up to the prescribed weight and hand stitching the gunnies and stacking in the same godown, inverted comma, close. And the item number, an item specified at serial number 3 and 4 would be termed as, inverted comma, destacking and loading into truck, inverted comma, closed. It was further mentioned that the CAG observed in their report that upon scrutiny of the bills passed by the FCIDO Nagaon, it was found that the FCIDO Nagaon had passed the bills providing separate remuneration for breaking of stacks, item number 5 of the NIT, and weighman, item number 3 of the NIT, though they were not admissible. It was further mentioned in the said report. It was further stated that the item number 1 and 2 of the price bid were actually the single operation in any PPC. And similarly, item at serial number 3 and 4 were also single operations. And it is under such circumstances, steps were taken, under such circumstances, upon making necessary calculation, it was found that there was an excess payment of rupees 18,77,217 to the petitioner. And after deducting the amount of rupees 8,73,116, the notice was issued on 15/9/2021, directing the petitioner to pay the remaining. It was further mentioned that out of the 7 works specified in the NIT, the works at serial number, the works pertaining to breaking of stack and restacking, and supply of casual labor were never undertaken. And as such, no payment for these items of works were payable to the petitioner. It was also mentioned that irrespective of multiple items of the work defined in the NIT, remuneration was due to the petitioner against only those items where work had been actually undertaken. In the backdrop of the said, you have filed a reply? No.
No, my lord.
In the backdrop of the said pleadings, this court have also duly heard the learned counsels appearing on behalf of the parties who made submissions in line with the respective pleadings. I've heard the learned counsels appearing on behalf of the parties and have perused the materials on record. The materials on record would show that though the contract that the record would show that the notice inviting tender dated 26/12/2021 was issued for appointment of a Mandi labor contractor. The works which were required to be carried out by the Mandi labor contractor have been duly mentioned in the notice inviting tender. And the price bid and it was, the said notice inviting tender further stipulated as to how the price bid is to be quoted, that is, as per ASOR. The notice inviting tender further stipulated that a contract to be awarded had 7 components, and on the basis thereof, the rates were to be quoted as per ASOR. This court have duly taken note of the appointment order of the petitioner dated 4/1/2017, wherein it has been also mentioned that the petitioner have been appointed as the Mandi labor contractor for the PPC Nagaon at the rate of 319% ASOR. During the course of the hearing, this court inquired with Mr. B.K. Singh, the learned counsel appearing on behalf of the respondents, as to whether there was any provision in the contract by which there could be bifurcation of the work so that payment could be made bifurcation of the amongst the 7 components of the work so that the payment could be made against each component. The learned counsels appearing on behalf of the respondents, referring to the SOR, says schedule of rates, stated the manner in which the rates were to be quoted. It is the opinion of this court that the rate as to how the rate at which it is the opinion of this court that the SOR as to how the price bid is to be quoted is different from a provision being there in the notice in the tender documents or in the contract entered into by and between the petitioner as well as the respondents, that there can be a bifurcation against the work actually done. for the purpose of making the payment. In absence thereof, it is the further opinion of this court that the objections so taken by the CAG that that there should have been that item numbers 1 and 2 should have been combined together. Item numbers 1 and 2, as well as the item number 3 and 4, should have been combined together. And such rate should not have been granted at a stage after, long after the completion of the project is not permissible. And adherence to such observations made by the CAG and thereby implementing against the petitioner renders the action on the part of the respondent authorities unreasonable, unfair, and arbitrary, resulting in violation of Article 14 of the Constitution. Consequently, it is therefore the opinion of this court that the impugned notice dated 15/9/2021 as well as the impugned order dated so and so 7/9/2022 are contrary to law. For which appropriate redirection and order is required to be passed. It is the further opinion of this court that as the respondent authorities cannot, as the terms and the conditions of the tender do not permit segregation or bifurcation amongst the components, the action on the part of the respondent authorities to do so and thereby to hold that the petitioner is not entitled to certain amounts for which the notice, payment notice was issued on 15/9/2021 was issued, being bad in law, comma, the question of depriving the petitioner of the security deposit would be illegal and arbitrary. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The impugned public payment notice dated 15/9/2021 bracket annexure A2 to the writ petition, as well as the order dated 9/8/2022 bracket annexure A7 to the writ petition are set aside and quashed. Number 2, the respondents herein are directed jointly and severally to make payment of the amount of rupees 8,73,116, which is the security deposit to the petitioner within a period of 45 days from the date a certified copy of this order is served upon the respondent number 3. It is observed that if such payment is not made within the period so directed, the petitioner would be entitled to interest at the rate of 9% on the said amount till realization.
I will complete the formalities. My lord, the formats I'll have to be signed. I'll sign, my lord, for getting the security. For last 4 years, it is there because of this case. Observing.
It would be entitled, number 2, the petitioner would be entitled to the security deposit of the amount of so and so. The petitioner shall produce
No demand
a
certificate.
copy of this present judgment and do the needful,
Yes.
so that the respondent authorities would be in a position to refund that security deposit of an amount of rupees so and so to the petitioner. It is observed that the same be done within 45 days from the date the petitioner completes the formalities. Yes, what is this? Oh, this one.
Well, in fact, Malad, recently, Malad, we have demolished the building, Malad, that fourth floor, Malad.
Third floor?
And well, third floor in view, there is a, Malad, I'm coming, Malad. Almost completed because in the roof we have and so
Is anybody residing on the third floor?
Malot, I'm coming, Malot. Malot, this is a medical document, the petitioner, the writ petitioner in item note 11. He went to Delhi to, in view of the ailment of this brother, Malot. He is doing the demolition process, Malot. It's being continuing. In fact, Malot, let's just put a question regarding that third floor. Third floor, in view of this order passed in item number 11, there's a protective order.
Item number?
Item number 11, Malot.
So we vacate it, na?
Malot, I'm coming, Malot. I'm coming, Malot. Malot, in item number 11,
The
Malot.
question of regularization does not arise in view of the judgment of the Supreme Court.
Malot.
Isn't it, Mr. Nayak?
Yes, that can be done then.
Huh?
That last judgment.
Malot.
So we vacate it. Go ahead.
The order dated 29/8/2025.
You are doing it with hammer. Only
Malot,
small hammer.
we are doing it, Malot. We are not.
You are doing it with.
Disregarding
small
it,
hammer.
this honorable
It
court
doesn't
order,
look
Malot.
like.
Malot, now coming to Malot, my writ petition, Malot. Item number 11, Malot.
To verify the demolition of the answer to now the man, the ground floor was observed to have.
Demolish the entire ground floor has been cleared.
Demolition of the was being carried out by the respondent as on demand first was observed to be there. Ground floor is being demolished means why?
No, we have already completed that portion. Ground floor, which was objected by the petition person, it has already been cleared, Malot. Malot, regarding fourth floor, this is the position, the photograph disclose the position before losses, Malot. And it's being continuing, Malot.
Now, what is the problem? Yes, petitioner.
Malot, and
You are, what is your name?
Sanjay Sharma.
Yes, come here. Let us hear you.
Your Lordship, regarding the ground floor, one unit is still pending, that is to be list. Luckily, he has given the photograph. I also brought the photograph of fourth floor also. And regarding the item 11, my
Now,
point
why
is.
are you against the building? You are a resident in the
Yes,
building?
yes, I'm resident.
Okay, why you are against the building?
No, sir, it was permitted for G+2 and G was only for parking. So where our vehicles should be stored, 4 number of units of flats was constructed and given on rent. And even in third floor, he's still getting a monthly rent of 30,000 to 40,000. And regarding the item number 11, he is saying that there is a protective order. Here I want to submit that this petition was filed on the wrong ground, that they didn't receive the demolition order. Here I am giving the order, and I don't know why the GMC Council didn't object at that time. The notice has been issued to the Jairul Islam, the private respondent. So this petition was filed on the wrong ground. So
who are you in that building? You are a.
I am the flat owner, Your Lordship, and he is Montu Kolita. He is represented there. So he is also a flat owner in that.
I'm also Dave.
He is on the second floor. I am on the first floor.
How many flats are there?
There is 8 flat. 4 floor at each unit. 4 flat at each first floor and 4 floor 4 unit at second floor, that's all. That is on the authorized G+2.
And above that,
Above that, third floor is illegal, declared unauthorized. And fourth floor was also constructed, that has been demolished, and that was also declared unauthorized.
so why are you against the third floor?
Your Lordship, we didn't have the terrace, access to terrace.
Now you will have terrace?
No,
The-
no,
why?
third floor is entirely constructed.
So
Half portion is,
above the third floor, you will have the terrace?
no, Your Lordship, and secondly, one thing, Mr. Dida was telling that one flat has been sold to the owner. That is their object, that is their interest to protect the third floor. And here I am giving an affidavit, sale deed only agreement. And that person came to me when we told them that this third floor will be demolished. So here is the sale deed only notarized and not even registered. This is the
I'm
sale
not
deed.
concerned with those. But the fact remains, why are you objecting to the third floor being demolished?
Your Lordship, that has been illegal, unauthorized. Permission.
Illegal, the GMC will look into it.
Yes.
Why are you concerned?
Because Your Lordship, our access to terrace has been totally blocked.
No, why I'm saying so? Earlier, for G+3, it's a different aspect of the matter. Now it is being given as G+2.
Yes.
And G+3 is different, G+4 is different. But nowadays, I see wherever the parking is given in the ground floor, first, second, and third is being allowed. Isn't it? Whether you allow or not, it's another aspect, but it is allowed.
In this case, permission was for a basement and ground plus 2. But no basement is there. In the ground floor, it was used, it is under use as it should have been used as a parking place.
So now it has
Now
been
it will be
broken.
clear.
Now it will be
It's been
parking.
Only
So-
one flat is still remained to be
There-
demolished.
Permission was
Now-
ground plus 2.
Ground+2, it's okay. But you normally allow, I could see, as per your recent bylaws, you allow ground floor plus G+3
No.
in
No.
small areas. That is why I see in all the
Different section lots, but in this case, permission was for basement, ground floor, and ground plus 2.
G
But
plus
no
2.
basement is there. Now only ground and 2.
So that is okay. But what objection you have with ground+3?
Lordship, there is no terrace and there is no terrace access to terrace.
What?
We don't have any access to the terrace.
Where is your right of going to the terrace?
Because you are for clothing and for others works also.
No, where is your right to go to the terrace?
Yes, that is there.
Where?
In the sale deed, Your Lordship. Show me. And second, Your Lordship, my point is also there.
Your point, I'll look into it. But show me where is your ground, right of going to the terrace.
Original petition, page number 21 to 30. Yes.
Where is your right of terrace? Huh? Where is your right of terrace?
Just a minute, Your Lord, coming. Your Lordship, I would request to come on page number 25 of it.
I've read it. Where is your right of terrace?
Your Lordship, I'm requesting you to come on the page number 25 of it.
Okay, 25, where is your right of terrace?
Admits a flat bearing number 20 to schedule B.
Ah.
950 square feet with proportionate share of land measuring 0.53 AR. Situated on the first floor of the RCC building along with a parking space. So, which was standing over a plot of land described in Schedule A above the said plate is honored.
Where
So,
is your right of terrace?
just a minute, Your Lordship, I am coming.
Yes, come.
0.53 acre ARC. So in my reply to additional affidavit filed by the in
I'm
opposition,
asking you, where's your right of terrace?
purely your lordship, terrace we have the
Then you
right.
don't have any right to dismiss your petition. When is this type of thing? GMC will take action whatever they feel like. Why is GMC not doing it? Let's see section 337 of the GMC Act. 337.
Yes.
337. GMC. GMC. If any building is erected or in contravention of a development or without the plans having been deposited or notwithstanding the rejection of ER, man may without prejudice to the right of taking an ER such manner by notice to the ER either require him to pull down or remove the work, or if so he so elect to effect alteration itself or a man. If any case in which the erection or erection has been commenced or is being carried out unlawfully in so and so made by written, if a person to whom a notice has been issued in the foregoing month fails to do shall pull down the work in question or effect such alteration therein as he deems necessary and may recover from him expenses incurred by so and so in that recoverable. Kindly come to 337(3). Why you are not taking action in terms with 337(3)?
That has already been done. Lordship.
You have not done that.
337, Lordship, this is 337(1)(2), then 337(3) on 25/10/22.
No, what have you done as regards 337(3)? Read the provision. What does it say?
Lordship.
Why have you not taken action this? Recover him from him as an area of municipal tax. Take that demolition. Because I remember while demolishing the Priyanka Estates building after the Supreme Court, it was done by the GMC and then recovered it from him. The owner.
But that is the law, Lordship.
So then why you are not taking that?
No.
That is why he has approached this court.
No, earlier it was not done, Lordship, but subsequently.
No, you see, this is what they are saying.
Yes.
They are coming up with all excuses. They are not you have given him, okay, you demolish it by your hand so that it does not demolish, has any effect on the building.
Yes.
That is why you did. Now, if they are not doing it, you could take the law.
In the meantime, they have already started demolition. Fourth floor is no more there. No more means it has almost demolished. Third floor
They've not
has not yet been
started.
touched. No,
Have they vacated?
not vacated.
Why? If it is an illegal construction, why they have not vacated till now? I'm not concerned with that. If this is not a matter going on today, they've been going on for long. There's a demolition order. Why they have not vacated? Who are the people who are there on the fourth floor? Third floor? Third floor, who are they?
Third floor, one of the rented people.
Your tenants. Your tenants, all these are. Then why they have not vacated?
They were out.
Then who is there?
In view of this, this protective order, we oppose.
No, that order is nothing remains. But the question is, you see, if you had come bona fide, I would have protected you. But I'm not going to do that. This doesn't seem to be proper.
We have already vacated the third.
No, you have not. Who is staying in the third floor? Who is staying in the third floor?
Appropriate instruction I will provide your losses.
Tomorrow. Tomorrow, we have court day after.
Can it be Monday, Malad?
First, let us have a bad day for you. On which we demolish.
Lordship, may I make some submission?
Don't make, you have no case.
No, your lordship.
You take a
regarding the
seat.
third
No,
floor.
you don't have any case. Take a seat.
Malad.
Otherwise, Mr. Naik, you take action under 337.
Lordship, in the meantime, one order came in respect of ground, third floor, Lordship.
I'll make it.
One aspect, Malad.
Yes,
I produced a document, Malad. Before your lordship, definitely I will telephonically obtain the instruction from my client. Presently, he in person is at Delhi.
So
For the
what?
treatment person, Malad, that is why, can it be on Monday, Malad?
Why?
So that appropriate instruction I can
You
produce.
have
to your
given
lordship,
2 days time is being given. I would have given hours. This is a case of demolition. You've been taking every
For
day.
humanitarian ground, nothing else, Malad.
Huh?
He remains, he have to rush to the.
Call up, telephone, video call, do everywhere. You don't need to meet him in person. He also knows.
Malad, definitely.
He also knows that he is,
The demolition
it is
person
not
has been
that,
not
Mr.
solved.
Counsel, it is not that it has come for him.
Demolition
It
process
is for the
is going on.
first time, he has come to learn that they are going to demolish. It has
Demolition
been
process
going
is
on for the
I
last
just
10
want-
years. No,
Malad,
it is going on for the last
Malad,
10 years.
Malad.
He should have gone them, asked for this before he has initiated all this process. No case. Saturday. In the meantime, we vacate that order in view of that order passed by the Supreme Court. Sure. You have no right. We close your petition.
First petition is concerned, they should concern only with the parking area, Lordship.
Yes, you are concerned with the parking area, you have got the parking area matter over. Nothing
If that
remains.
vacated, Lordship, beyond that, Lordship, you cannot, should not have any.
See, Mr. Sharma, question, all these other aspects are different. Pertaining to whether they have violated the GMC Act, it is a different aspect. But for you, the only issue is the parking area.
One
Very
flat
well.
is still remained, your lordship.
Now you
That-
have got the parking area
One flat is yet to be demolished, your lordship. I have given you
of
photograph.
the ground floor.
In the ground floor, in parking area. I'm giving you the photograph, your lordship.
Are you sure?
Yeah, I'm giving a photograph, your lordship.
Okay. Then the inspection report is wrong, Mr. Naik.
This is the photograph, that photograph given by you. This is the photograph of ground floor. It's a flat, but zero.
Who is demolishing it? The ground floor?
The GMC demolished it on 19th August, but this flat was not demolished. And this is on the parking area.
I will have the instruction. So
We have it day after that.
today's report, Lordship, ground floor was observed to be demolished. The demolition being carried out by GMC at on an earlier date.
What is being?
Now he is saying.
Have it been completed? The ground floor is vacant or not? Otherwise, I'll appoint an advocate commissioner. If, and don't make this court not trust the GMC officials. Yes, Mr. Gusami,
Regarding parcel to your lordship.
I'm asking you, ground floor, has it been demolished or not?
As part, since the GMC has.
I'm asking you. You know
I'll, appropriate instruction I'll provide on the
First.
next day.
first.
Mal. Another suit, can I? vote?
Yes.
In view of the interim order passed in Item 11.
I'm beginning that.
I am coming. We are approaching the GMC authority with a review application with a prayer to regularize the third floor. And it is pending, we are expecting to a positive sign from the GMC within a span of.
The council out here for the GMC is not showing any positive signs. He has shown a judgment of the Supreme Court.
Letter, my lord. My lord, that is why I
That
apprise
has
you.
already been rejected.
Development. my lord.
One against the demolition order, an appeal was preferred before the Payoting Council for paying for regularization. That has already been rejected. It was rejected on 13/5/2025.
And that is why we deferred it, item number 11, and subsequent to the order, Malak, passed by the lordship, we approached the GNCO authority with a review to regularization. We are expecting a positive response from them.
We are
I
expecting a
applaud
positive thing.
Malak, positive response from the GNC authority, that is why I applaud
Okay,
your lordship.
list this matter on 1/11/2025. On which date? Both the, on which date? The Mr. UK Gustami, the learned counsel appearing on behalf of the petitioner in WPC number 5024/2025, as well as Mr. P. Naik, the learned counsel appearing on learned standing counsel of the GMC, shall apprise this court as to whether the ground floor of the building in question have been completely demolished. Full stop. Take it up. Third floor will consider later on. You appear on that day. Come up with another fresh photo.
Should I appear now, Your Lordship? Should I appear on the first now?
There, on
Yes,
third also.
of course.
First also. Mr. Nayak, you get this ground floor demolished so that his case can be closed. Sanjay Sharma's case can be closed. Let him go away.
I'm communicating today.
Third floor, we will look into it, what can be done. It can be something, because it can be regularized, because if there are other persons out there, can be done or not, we'll consider. But as regards the ground floor, you get it done. So he also is satisfied, then there's less of problems.
Lots.
But I have filed affidavit, probably they are on the same.
Yes, what is this?
My lord, today the affidavit has been filed, my lord, so I'll file reply, my lord. 3 weeks may be granted.
Has been submitted that an affidavit has been filed on behalf of the district judge Hailakandi. Today, to submit as your name is. Here is a case where petitioner does not Ms. S.B. Chaudhary appearing on behalf of the petitioner seeks for some time for filing the reply. List this matter again on 20/11/2025. In the meantime, the reply we filed.
Yes,
We'll dispose of on that date.
yes.
Article number 17, supplementary text.
এই কেসত ভৰাই দিব না কিন্তু আগত লাইকৰ কেছটো আছে Yes, what it is?
My lord.
Oh,
Medical
RP.
That, my lord.
Okay.
The only core issue is whether by change of the name of the company, it becomes a different company. They have
No, no, you were a public private company, you were a firm or a private limited company, became public limited.
Yes.
Isn't it?
Yes, my lord, that is publicly
The
limited.
name
and
also changed.
Name is changed.
No, entity is different.
No, my lord, regarding change of the from private to public limited company, my lord, is very clearly mentioned in the act itself, my lord. The act itself very clearly says it.
Private limited company, the people are less than 50.
Yes. Yes.
Public limited company, more than 50. There are various other restrictions comes in.
But whether the all contracts, agreements, legal proceedings, which were pending before the earlier company, can that everything get evaporated? That no, that will be binding upon the company. All the
I understand your argument would be on the lifting the corporate will.
No, I would write the section 18 of company regarding the conversion of company.
Huh?
Section 18 of company.
Companies Act 2013. What does it say?
It said that a company of any class registered under this act may convert itself as a company of other class under
Section 80.
Section 18, 1(8).
1(8). Hello, one interesting matter. company or any class registered under the You are on 18.3.
18th. 18th.
So it is a case of a fresh registration. Fresh registration upon being made, changing the nature, class of the company, and the name being changed.
Name will change. Actually, the registration will with effect it will be with effect from the earlier time. That your worship will
And do you have anything? If the name is being changed, it would also not impact.
anything.
How can a name be changed? Do you have anything on
Name
the
change,
company
my
that
lord,
say anything?
it is my lord. Name change is section 13, my lord.
Section 1.3,
1
alteration of the memo.
completely. Any change in name of company shall be subject to the provisions of section 2 and 3 and shall not have effect except with the approval of central court.
You have got the approval of the central government in the changing of the name.
Name has been changed, and after changing them, they have issued us another certificate of incorporation. Certificate of incorporation with new name has been given to us.
So your name now is
Name now is RV Engineering Consultants Limited.
RV Engineering.
Engineering Consultants Limited.
So here it is not normally if it is made from private limited to normal limited or just limited company, then the proviso to section 13.2 will apply, isn't it?
Yes, madam. And madam, it was duly a certificate of incorporation has been issued, my lord. That may kindly be.
But now with the approval of the central government.
That is why they have issued a certificate of incorporation, my lord.
Huh?
Certificate of incorporation will be given to us.
By the central government or the register of company?
By the register of company.
No. Approval is where?
My lord.
There has to be an approval as for 13.2.
I can do it only after approval of only after approval. My name is changed, and after changing the name, they have given certificate of.
So where's the approval?
Approval I have not filed here. With approval we have not.
No, you have a copy of the approval.
I can ask for that. I can ask for that, my lord.
Find out. If it is the approval is there, then applying the other one. Because if you just want to remove the private, then approval is not required. But you are changing the name from architects and all to engineering. So therefore, there will be a requirement of the approval.
Name change.
Finally come to 13.2.
Subject to provisions of
13.2.
For the assembly of taken effect provided only when private. If the private only private is changed, that is different.
Then it is not required.
No such provisions.
But otherwise, the approval will be required.
Private consequent on the conversion of.
You need to find out that. And what is the status of the contract? Status of the contract?
That part, when you dealing with this, I have to.
Huh? Is there a fresh tender process? Or it was cancelled?
Cancel.
You obtain in that instruction. When can we have it, Mr. Kutama?
Saturday. Day after tomorrow, my lord. Day after.
Because if he has that,
No.
then it may have to be reconsidered by you. In view of section 18 and section 13. Eh, Because section 18 categorically says that making it from public to private, private to public, would not change his rights over the contract in respect of any contracts or anything. So therefore his submission or anything about this thing he will continue to remain as so. Now, if the name is changed from RV in so and so with the approval, and Mr. Sharma also find out that aspect with the approval if it's changed, because 18 says about change of the class. Then they continue. With the change of the name, what is the impact? Just find out that also.
Regarding that, central government, I think it is there.
Huh?
Page 40, my lord. Certificate of incorporation, it says that. Certificate of incorporation, my lord.
Page 40.
Page 40, my lord.
In the matter of so and so, I hereby certify was originally incorporated in so and so as RB in Kerala, and upon an intimation made for conversion of the public in under so and approval of the Senate signed in writing has been accorded thereof by the ROC so and so, the name of the company is changed from so and so. So the approval is there. So if the approval is there, what is the impact of this approval as regards the term contract? Would they still continue? I think then they will continue in view of this. Find it out. Huh? We'll like to finish it off because I have not passed an interim order. Saturday? Saturday, I have already many more matters, 5, 6, 7. But the other matter won't take. Okay, list this matter again on Saturday for further hearing. Or say on 1/11/2025 for further. Only on that aspect, what is the effect? If it is not there, then I think you should have to consider it.
It will be a part so that it can come earlier. No? Otherwise, it may be listed in last item. That is main problem.
Mr. Sharma wants to go home on Saturday early. So, huh? I gave a permission today, tomorrow at last night. Yes, what is this?
Lordship, the last order dated 11/9/25 may be produced. Lordship. The promotion of the respondent number 7 was challenged here, Lordship.
Okay, no affidavit filed.
No, yeah.
Well, we take up for disposal. Your case is what?
The records, my lord.
No records. I don't need the records. Why should I look into? No record.
Thing is there, my lord. Lordship's order dated 21/8/2025.
Oh, this after this nothing remained.
It's wrong, my lord. The selection is wrong. If your lordships, that order is made final, then it's
Why should I write so much?
because
I say that in view of that standard, the court have the High Court have duly accepted this. The record, I passed this order on the basis of records.
yes, yes.
So there is nothing else.
And your lordship's order is.
You are
correct.
for. Okay. Where is the respondent? 7.
Private respondent. Okay, there is a problem.
Copy was
No,
served.
7 is.
Okay, service has been completed.
Promotion right there.
Deep Chopra. Because one is all right, Malik, but the second one, there is problem with that.
What?
Supriya Chakraborty.
No, we are not concerned with them. They have also mentioned it. I recorded it in my order.
Yes, Malik. So far as,
Now that we have not even issued notice to 6.
yes, correct. Lordship was not inclined to issue.
And I have not issued to this one, 5, 2, 7, 8. As regards respondent, this court is not inclined to issue.
Yes, yes. But other, my lord, the selection committee's conclusion is wrong, my lord. It was done on merit. That could not have been done.
Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das, the learned counsel, learned standing counsel for the Guwahati High Court appears
2 to 6.
on behalf of the respondent numbers 2 to 6. Mr. S.R. Borua appears for the respondent number 1. None appears on behalf of the respondent number 7 in spite of service being affected upon the respondent number 7 and duly noted in the order dated 11/9/2025. This court had passed an order on 21/8/2025. Had passed a detailed order on 21/8/2025. And holding inter alia that the selection of the respondent number 7 to the post of, what is the post?
Senior administrative.
Post of senior administrative assistant
Yes.
was contrary to the criteria, contrary to the principle of seniority cum merit. However, as on that date, the respondent number 7 was not present, this court did not allow the writ petition without giving the respondent number 7 an opportunity of hearing. It is seen that in spite of notice being given, the respondent number 7 had not appeared. Mr. H.K. Das, the learned counsel, appearing on behalf of the Guwahati High Court, further submitted that the respondent authorities duly accept the order dated 21/8/2000, the findings in respect to the order dated 21/8/2025, insofar as promotion given to the respondent number 7 was considering the above, this court therefore.
May I just speak?
Yes.
Instead of placing in my mouth, can it be, you know, based on the records which I had produced?
That I have already recorded from the records only. I mentioned everything.
Reiterating.
There's
from the
nothing
record-
else.
Nothing else, my lord. Same thing.
So-
Reiterating the previous order passed by your lordship that those are in conformity with the record. Lordship will result a finding, my lord.
Then why you are not filing an affidavit? Oh, then like, you know,
I think.
I work in detail order. I get it. This court inquired with Mr. H.K. Das, the learned counsel, appearing on behalf of the Guwahati High Court as to why, in spite of due opportunity being given, no affidavit has been filed. The learned counsel, standing counsel for the High Court, have only produced the records which this court have duly taken into account while passing the order dated 21/8/2025. Full stop. This court further inquired with Mr. H. K. Das, the learned counsel appearing on behalf of the petitioner, as to whether any further submissions are required to be made in that regard. The learned counsel submits that he has not received any further instructions to make any submissions as regards in the instant matter, save and except that the promotion to the respondent number 8 is in accordance with the principles. So the learned counsel appearing on behalf of the petitioner have further submitted that the petitioners are not aggrieved by the promotion of the respondent number 8 by the impugned order dated 1/8/2025. Taking into account that this court have duly passed the order dated 21/8/2025 on the basis of the records, and there is nothing else being brought in, this court this court finds no ground to differ with the findings already arrived at by this court on 21/8/2025. Accordingly, the instant writ petition therefore stands disposed of, thereby interfering with the order dated order number 58 dated 1/8/2025, by which the respondent number 7 was promoted to the post of senior administrative assistant, as well as all such consequential orders passed on the basis thereof, which relates to the respondent number 7. This court, however, clarifies that this court have not interfered with the impugned order dated 1/8/2025 insofar as the promotion of the respondent number 8 to the post of senior administrative assistant. The respondent authorities would be at liberty to take steps for filling up the vacant post of senior administrative assistant, which now stands vacant in view of the setting aside of the order dated 1/8/2025, by which the respondent number 7 was promoted to the said post, as well as all consequential orders in connection with the respondent number 7. The petition stands disposed, interim order stands vacated. Records so produced are returned. Yes, any more matters? Oh, hearing. Gauripur Cooperative Society. And Lokinath Das. Dasni. All matters are over. Huh? No. Lokinath, this matter, we have 15 minutes.
Overqualification matter,
Which one?
this Lokinath Das.
Ah.
And the authorities, they initiated a departmental proceeding. That departmental proceeding is at the argument stage.
What is there to argument?
There is
Argue these
nothing,
type of matters.
Lordship's order is already there.
We should dismiss. You are there?
No.
Who is there? Item number 16. Let me complete the list. 4:30. The courts rise at 4:30. Nobody knows.
Earlier it was 4:45 Milo.
Huh?
It has changed because of the winter Milo, 4:30.
Anyways, nobody knows that. So we take it up. Where is the council?
Yes,
Mr. P. Monto. Huh?
Council is. It's there in the pause list. Milo. Somebody he told me that's there in the pause list.
Was list for what?
4:30.
I don't see the file or cause list ever. What about 15? See, 15% will come.
15 is a settlement matter.
He has arguments.
It's a settlement matter, my lord. fishery settlement. There is no stay order, but
The fish has played the role here, my lord. Fish has played the role in either between.
next week, my lord, if it's not inconvenient.
What is the matter?
It's a settlement. We have challenged the settlement granted to the private respondent, my lord.
Then
Against that, we had filed a writ petition. The pleadings are complete, my lord.
so you admit it, listed for hearing.
It's already fixed for hearing, my lord. Already fixed for hearing.
Oh, is hearing?
Yes, my lord.
Hello. Then we list it in the usual course.
The settlement already 3 years have gone by, my lord. So after 2 weeks, my lord.
Where's the other side?
He's
Ah,
there.
she's there. She's ready to do the math. Ready now? But the problem is that the fishery people is not there, na? P. Sharma. Huh?
They were engaged in the last part of the member parties. So we are hearing
Anyways, nowadays for fisheries, everybody appears. Means from the government, everybody appears.
Here appear good many cases of it's a be a comment after
Madam, you have a good case? Huh? Then we adjourn it silent.
Or on Saturday, my lord.
Huh?
Saturday, first is
Absolutely no. Saturday. No judges are fixing and I am the only one fixing matter. List this matter when?
after 2 weeks, my lord.
I won't be here then. We'll have it on 18th. At the request of the councils, the matter stands adjourned to be listed on 18th of November 2000.